Hello? Hello, yes.
Let me ask you a question. If you were physically in the courtroom, would you come into a courtroom and say hello to everyone in the courtroom? The answer to that would be no. So don't do it on this Zoom screen. Everyone, we've been using Zoom for well over 2 years now. So everyone should know the rules. And who is listed as Moto G Stylist? These are the rules for the 187 District Court. If you cannot put your proper name on the Zoom, you will not be allowed to use Zoom. So the person who's in the blue shirt who's driving, what is your name?
Samantha Saldana.
Are you wearing a blue shirt?
Garcia Roper.
Yes, you need to drive yourself to the 187 District Court. Your Zoom privileges are revoked. You will not be allowed to use Zoom anymore. Do you understand?
Yes, ma'am.
All right, you're in the 187 District Court. These are the rules of the court. You are in a courtroom. If you do not behave appropriately on this Zoom screen, your Zoom privileges will be revoked permanently. I'm going to open the breakout rooms. When I open breakout rooms, it's going to invite everyone to go to a breakout room. Do not, I repeat, do not go to a breakout room unless I specifically call you by name and assign you to a breakout room. We are going to resume our jury trial at 1:50. So if you see on the clock that it is 1:50, do not come back in the main room. When I am ready for you to come out of the breakout room, I will come and get you from the breakout room and request that you be removed from the breakout room. All right. Just one moment. If there are any attorneys who have not been made co-hosts, please put it in the chat box with me. To the parties on the screen who are defendants or accused, you will hear your attorney's name. You will not hear your name called. If you do not hear your name, it's because your attorney is Zooming in another courtroom. You need to be here and be patient. If you cannot be here and be patient, what's going to end up happening is you're going to be required to be here and be patient in person in the 187 District Court. There's to be no laying in bed. There's to be no cooking of food. If you behave inappropriately on this Zoom screen, your Zoom privileges will be revoked permanently. To attorneys, if you have a plea bargain agreement with the state, no matter how small you think that plea bargain is, you need to put it in the chat box. And you need to put that in the chat box to Ms. Ferguson, the court coordinator. She'll be listed as Ferguson coordinator on the Zoom screen. If your client is on bond, you will need to put into the chat box your client's email address. All right, this is the order in which attorneys will appear: Paul Vasquez, Robert Maurer, Miguel Hernandez, Amir Memori, Robert Porter, Elizabeth Settle, Brian Kimbrough, Jeb Locke, Ernest Acevedo. Are there any attorneys that I have missed?
Yes,
Callahan.
Nathaniel Navy, who else?
Callahan.
Jonathan
Anyone
Ross, Your Honor.
All right, anyone else?
And Sean Simpson, Your Honor, I'm here for Jennifer Zarka.
All right, attorneys, you know the rules. Add your client's name, and whether or not it is criminal trial division or family violence, I will assign you to a breakout room. Again, we are in the middle of a jury trial. So if you are not completed by 1:50 p.m., do not leave your breakout room, remain in your breakout room. The prosecutors have the ability to move in and out of the breakout rooms. They have the ability to send your client where they are needed. Paul Vasquez, let me see.
Good afternoon, Judge.
Yes, I'm going to send you to breakout room number 3.
Excuse me, Judge.
Yes,
You didn't call my lawyer's name.
yes. All right, Robert Maurer, I'm sending you to breakout room number 4.
Okay.
Miguel Hernandez. I'm going to send you to breakout room number 5.
Thank you, Judge.
You're welcome. Amir Mamori.
Your Honor, we have a plea agreement about Raymond Cristo. I've completed the DA's paperwork. I'm waiting for Norma to email me the court's documents, and I've emailed her and let her know, Your Honor.
All right, I'm going to send you, what is your client's full name?
Raymond Cristo, Your Honor.
All right, I'm going to send you to breakout room number 1. Is your client in custody or on bond?
He's on custody, Your Honor.
All right, Mr. Cristo, please go to breakout room number 1.
Judge, as far as Ms. Ferguson sending me the documents, I've looked at the chat. I don't see her name posted there, so I'll just wait for her.
She's listed as Ferguson coordinator. And she will get your paperwork to you.
Thank you, Your Honor.
You're welcome.
May we go to room 1?
Yes, you're in room number 1.
Thank you, Judge.
Robert Porter.
Good afternoon, Your Honor.
Good afternoon. I'm going to send you to number 5.
Thank you, Judge.
Elizabeth Settle.
Judge, good afternoon. We're here on a plea for Deja Garcia, but this plea was, you may remember from last week, it's contingent on a plea in County Court 13. The earliest date or time that Sybil could give me was today at 3:30 for the misdemeanor plea.
Excellent. If you'll take care of the plea over there, then zoom back in here.
Okay, may we be excused until then?
Yes,
Thank you, Judge.
you're welcome. Brian Kimbrough.
Here, Your Honor.
All right, I'm going to send you to breakout room number 6.
Thank you.
Robert Porter, I think, should be in number 6. Just one moment. All right, I'm going to send you to number 7, Brian.
Okay, thank you.
Jeb Locke.
Hello, Judge.
Yes, who do you have?
Joaquin Alejandre. It should be family violence.
I'm going to send you to number 8.
Is
Thank
Butler on
you.
the free world?
No.
He's in jail, right?
Ernest Acevedo.
Good morning, Judge. Juan Carvajal, CTD case.
I'll send you to number 9.
You-
Nathaniel Navy.
Good afternoon, Judge.
Send you to number 10.
Thank you.
Denny Callahan, I know what you're here for. Just give me a moment.
Okay.
Jonathan Ross. I'm going to send
Yes,
you
Your
to
Honor.
number 11.
Thank you.
Sean Simpson. I'm going to send you to number 12.
Thank you, Judge.
Charles Bonk.
Yes.
What do you have?
Or good afternoon, Your Honor. We're here on that one as well.
On what? Who's speaking?
Is the defendant, Your Honor.
All right,
On
so-
that case with Mr. Bunk, he is the Daniel De La Garza and Joel Perez.
All right, I'm going to send you all to number 13.
He's the special prosecutor on that case.
Thank you. I'll send you to 13.
Thank you, Your Honor.
You're welcome. Michael Sawyer.
Your Honor, I'm here for Gabriel Potlan.
Is that criminal trial division or family violence?
It looks like criminal division, Your Honor. It's a drug case.
All right, I'm gonna send you to number 15.
Thank you, Your Honor.
I'm sorry, 14.
14, okay.
Jerry Kagan.
Hi, Judge.
Yes, who do you have?
Valentin Ramses Ramos.
Criminal trial division or family violence?
CTD.
I'm gonna send you to number 16.
Thank you.
All defense attorneys been signed to breakout rooms? All right, Denny Callahan, you're here with Mr. Watson, correct?
Yes, ma'am.
All right, Mr. Watson. Can you unmute for me, please? Just hold down the space bar. It's the longest key on the keyboard.
Can you hear me now, Your Honor?
Yes, I can. All right, Mr. Watson. So I talked to the state and the defense. What I'm going to do is I'm not going to have GPS on you, but you are going to have to report to pretrial services weekly. Do you understand?
Yes, ma'am.
All right, now, Mr. Watson, if you don't report to pretrial services weekly, what's going to end up happening is they're going to send me a violation report. And if that violation report is in order, I'm not going to call your attorney. You're going to have to speak to me from custody. You understand?
Yes, ma'am.
All right, so how often do you have to report to pretrial?
Once a week.
All right, so we're going to still have your trial date for May 23rd.
Okay.
So that's still set. And you're still going to have to appear in court on May, if you're released and are able to make bond and everything, you're still going to have to appear in court on May 23rd at 9 a.m. You understand?
Yes, ma'am. If I'm not mistaken, Mr. Sanders said that he couldn't make it that time, that he wanted to postpone it longer when I was in court this week.
No, we'll see where we are at that time, okay?
But you want me to come on the 23rd of this month?
Yes.
Okay. Yes,
All
ma'am.
right. And also, Mr. Watson, you're not allowed to possess any weapons.
Yes, ma'am.
So you know what that means?
Yes, ma'am.
It's just like at a restaurant. Now at restaurants, they don't even give you a real steak knife. It's just a butter knife. So that means no knives, no swords, no katanas, none of that. You understand?
Yes, ma'am. Bless you. I do understand. Thank you.
So you're welcome. So that's what I'm going to order, Mr. Callahan.
Thank you, Judge.
So has he actually made bond and the issue is just the GPS?
Yes, ma'am. Well, no, I don't know the answer. The reinstatement is the issue with the bondsman free.
Okay. Okay, well, what I'm going to do is I'm going to waive GPS requirements. And what were you asking the bond to be set at again?
20, I believe was last time.
All right. Was it 20,000 the last time, Mr. Sanders?
I'm checking now.
It went from 20 to 40, back to 20.
Okay.
That is a reinstatement, right, ma'am?
Just one moment, Mr. Watson. Yes.
I'm sorry to interrupt, Judge. Thank you for examining here. Is it okay if I have him fingerprint it now?
Yes.
Thank you.
All right, Mr. Watson, what I'm going to do is put the bond back, whatever it was previously set at. Your attorney thinks it's 20,000. I'm having the state check on it to see if it was 20,000 or less than that. But I will ask that the bond be placed at that amount. You'll need to talk to your bondsman. I don't know why the bondsman has to be released from bond for you, but that'll be something you'll have to work out with your bondsman.
They released, they got off my bond because Mr. Andre Watson that was in this courtroom, same name, that they charged me with it, his charge, and said that I got another charge. And that's why they came off the bond.
All right, so your attorney or you will need to speak to your bondsman, okay?
Yes, ma'am.
Judge, the last I'm showing it was 40,000.
All right.
I'd be okay with, I guess, splitting the difference and doing 30.
All right, I'll send you all to a breakout room to see what you can agree on a bond amount. I'll send you both to breakout room number 2.
Okay.
So, Mr. Callahan, I'll send you to 2.
Thank you.
Paul Vasquez,
Morning, Judge.
good morning.
We have an agreement on my motion to amend conditions of bond.
All right, you'll need to send that as an email in just one moment. Is
Send it
your
as-
client indicted?
No, Judge, they're night mag.
All right, let me see if I have that.
It was e-filed on May the 4th, if that helps.
Okay, how many cases does he have?
3.
I don't know why this hasn't been printed out. Just give me a moment.
Okay.
Judge, this is Joel Perez. We're back from the breakout room.
Just a moment.
Yes, ma'am.
All right, and cause number 651530, what is your agreement? You're on
The
mute.
order, I'm sorry, Judge. The order is accurate as it reads. The only thing Marcus would like to put in there are 6 a.m. to 7 p.m. the times.
Is this Monday through Friday?
Yes, Judge.
May I address the court, Callahan?
Just a moment. All right, Mr. Vasquez, are your numbers 651526 and 651528 and 651530?
That is accurate.
All right, then the court has signed the agreed orders. You and your client are excused.
Thank you, Judge. Juan, you can log off and we'll give you a call.
All right, and Juan Reyes, is Juan Reyes in custody?
No, Your Honor.
Where's Juan Reyes?
He's right there, Your Honor.
That's not telling me anything.
But what's it? It says
How's
John-
he
Sorry.
I'm here, Your Honor.
listed?
John Reyes?
Oh, wait, what is happening with Mr. Reyes?
Judge, if you recall, I'm scheduled now for pretrial hearings on June 1st and June 2nd on a death penalty case in Laredo. And after those hearings, we are intending to request the court to set us a date certain for trial so that I know where I can try Mr. Reyes's case. Now, we're also still negotiating and we might be close, but I would ask the court if you can bring us back after June 2nd on a status to see if I have a date certain for the Laredo case.
All right, do you have all the discovery?
Yes, Your Honor, I do.
All right, Ms. Ferguson or Mr. Juan Reyes, can I have a jury trial setting on that, please? And a plea deadline date, the same? All right, we're gonna come back on June 13th. That's your jury trial date. and your plea deadline date.
Judge, I'm out of country that week.
All right, when will you be back?
June, the week after, June 21st.
All right, Ms. Ferguson, are we available on June 21st? All right, so we're gonna set it on jury trial and plea deadline date for June 21st. All right, you and your client are excused.
Thank you.
All right, Mr. Watson?
Yes, ma'am.
Yes, Mr. Callahan?
We have an agreement, 20,000 bond, Your Honor.
All right, to the clerks, I need a B page on Mr. Watson. All right, if there's nothing else, you and your client are excused. Mr. Watson, remember the rules the court gave you. You understand?
Yes, ma'am. Am I being reinstated, bond, because I haven't done anything to revoke?
You'll need to talk to your bondsman about that.
How can I do that? I'm incarcerated.
You need to confer with your attorney.
Yeah, confer 1 minute, Your Honor.
Yes, Mr. Callahan, I'm going to send you to breakout room number 3. Mr. Watson, you're to go to breakout room number 3.
Yes, ma'am.
You're welcome.
Your Honor, can I please be assigned to breakout room number 10? The defense attorney I need to speak with is already there.
Okay. You.
And good afternoon.
Good afternoon.
Thank you so much.
You're welcome. Is there anyone else ready? Albert Charles.
Judge, that's my lawyer, but he's in trial right now.
Your attorney is on the screen as we speak.
Oh, he is? I don't see him.
Afternoon, Judge. Yes, Ms. Salcedo. I had told Ms. Salcedo I was in a merits hearing this morning. The judge broke at lunch and couldn't come back. So we're going to continue at another time.
What is your
I am
client's
ready. Allison Martinez Salcedo. And I can confer with one of the DAs if it's possible.
Criminal trial division or family violence?
It's a possession case, Judge. So it's not family.
All right, I'm going to send you to breakout room number 15.
Thank you, Your Honor.
All right, Mr. Memorial, we're going to take up your plea, then I'm going to place everyone else in the waiting room.
Judge, we haven't finished the, I'm still waiting for Norma to sign documents. I just came out to message her, Judge.
All right, thank you. Robert
Thank you.
Maurer?
Judge, Ryan and I resolved our discovery issue. So I think what we need now is a trial date, but I did want to address the court on the bond reduction that I requested on the cases.
All right, Ms. Ferguson on Guzman. I need a jury trial date, please.
Crystal.
Does he have two cases?
I'm not sure about the one with 3520.
Well, I can put one up. That was
Oh, you did? Oh,
yeah. Put one right here.
okay. I'm checking.
All right, thank you. All right, your jury trial date is going to be August 30th. Mr. Gooseman, your jury trial date is going to be August 30th. You'll be brought over from the jail in whatever clothing you were arrested in. If you wish to appear in something other than the clothing you were arrested in, then you'll need to make arrangements with your attorney. Mr. Mauer, if there are some issues with clothing, let the court know, and the court will see if they can help you expedite that.
Will do. And Judge, I filed writs on particularly the murder and the ag assault case have high bonds. He's been in jail for 3 years. There have been several motions for continuance filed by the state, and then we had this discovery issue it's caused, like, I think 3 separate resets.
All right, I'm going to start up a punishment case that should not take more than 35 minutes. So I will come back and address that at that time, but I can't address that now.
Can I just come over to the courthouse and do it?
Yes.
Okay, I'll just walk over there. I'm tired of sitting at my computer. Thank you, Judge.
You're welcome. All right, everyone, I'm going to send you all to the waiting room. And we will take up your matters after that.
Judge, is there any way, Lorraine, you can put me with a family violence or CTD?
What is your client's name?
Alex Martinez. And I think he has cases in each.
All right, I'm going to send you to breakout room number 17.
Thank you so much.
You're welcome.
Also, Your Honor, I don't have a lawyer.
All right, you're being placed in the waiting room. Be patient.
Yes, ma'am.
You're welcome.
Thank you.
All right, if you want to bring the jurors in.
Judge, he's actively preparing right now.
Okay. All right. Robert Porter.
Yes, Your Honor.
Yes.
Oh, you, I didn't know what you said. I thought maybe a breakout room. The state, Mr. Reed, does not have their file yet. It was transferred over from the 144th.
All right, and it is Terrence Reed.
Yes, Your Honor.
Ms. Ferguson, on Terrence Reed, can you please recall that in 2 weeks? All right, we're going to come back on June 7th.
Thank you, Your Honor.
And which court was it being transferred from?
The 144th.
All right. And is your client in custody?
Yes, Judge.
Do you need to speak with Mr. Reed?
I'm going to go by the jail and speak with him in the morning, Judge.
All right. Mr. Reed, your attorney is going to speak with you in the morning. There's nothing we can do today because your file has not been transferred yet. So your new court date in this court, the 187th, will be June 7th.
June the 7th?
Yes.
It's okay. Is there any way you could tell him to come talk to me? Because I ain't talked to him since he's been
He
my
is
attorney.
going to speak with you, Mr. Reed.
All right, thank you.
All right, and
Thank you, Judge.
let's not use double negatives, but he will come speak with you, okay?
Yeah, all right.
Thank you, Judge.
You're welcome. You ready? No, first, you have to read the, yeah, it's been a long day. Yes, we're gonna have it. Yes. All right, let's bring them in. Thank you.
All right, so jury. Just have it skip the wishes like that.
Okay.
Oh, yeah. Ready, Judge.
All right, thank you.
All right, so the jury.
All right, everyone, please be seated. I hope you all had a nice break, a nice lunch. All right, State, are you ready to proceed?
Yes, Your Honor.
Defense, you're ready to proceed?
Yes, Your Honor.
All right, State.
Habitual offender enhancement allegation. And it is further presented in a two-set court that before the commission of the offense alleged above, hereafter styled the primary offense, on the 27th of July AD 2009, in cause number 2008 CR 7919 in Bexar County, Texas, the defendant was convicted of the felony of aggravated assault with a deadly weapon.
How do you plead to that, true or not true?
Not true.
State.
Before the commission of the primary offense and after the conviction in cause number 2008 CR 7919 was final, the defendant committed the felony of assault family second offense and was convicted on the 27th day of October AD 2014 in cause number 2014 CR 5692 in Bexar County, Texas, against the peace and dignity of the state. Signed foreman of the grand jury.
How do you plead true to that? True or not true? I'm sorry, how do you plead to that? True or not true? All right. State.
Yes, Your Honor. At this time, the state would formally reoffer all of the evidence from the guilt portion of the trial. And then also we'd like to call our first witness.
All right, before that, do you have any opening statements?
No, Your Honor, the state would waive any opening.
Defense, any opening?
Waive opening statement, Your Honor.
All right, State.
Just to repeat what I already said, because I had to put this in order, Judge, I'm sorry.
No problem.
The state would formally reoffer all of the evidence from the guilt portion of the trial. And at this point, the state would call Manuel Alvarez.
All right, any objections?
Defense would have no objections not previously ruled on, Your Honor.
All right, then that is admitted. All right, call your first witness, please.
They call Manuel Alvarez.
All right, if you'll take the witness stand. All right, if you'll raise your right hand for me, please. Do you solemnly swear or affirm the testimony you present will be the truth and nothing but the truth, so help you God?
I do.
All right, you can lower your hand. If you'll please keep your voice up, and if you'll state your name for the record. Yes.
My name is Manuel Alvarez. I'm a fingerprint examiner for the Bexar County Sheriff's Office.
State.
Thank you, Your Honor. Mr. Alvarez, again, you're a fingerprint examiner with the Bexar County Sheriff's Office, correct?
Correct.
And how long have you been a fingerprint examiner with BCSO?
17 years.
And can you, the jury's already heard from a fingerprint examiner, but as far as you're concerned, in your training experience, what were the qualifications to become a fingerprint examiner?
Well, initially we had to attend a course, we had to pass the course, and we have to be certified.
And are you a certified fingerprint examiner?
Yes, sir.
Have you testified few or many times?
Many times.
Approximately, do you know how many times you've testified?
Over 100.
Over 100 times. And testified in courts here in Bexar County?
Yes.
So earlier today, or just a few moments ago, were you able to fingerprint a person here in the courtroom?
Yes.
And did that person identify themselves as Anthony Salinas?
No, sir.
Okay. Do you see the person that you fingerprinted in the courtroom here today?
Yes, sir.
And can you point at him, identify him by piece of clothing?
The individual to my left with a black shirt and a beard.
And Your Honor, may the record reflect this witness has identified the defendant. Your Honor, may I approach?
Yes.
Mr. Alvarez, I'm going to show you what's been marked as State Exhibit number 35 for identification purposes. Do you recognize the document?
Yes.
And what do you recognize it to be?
Yes, the fingerprint card from the Bexar County Sheriff's Office.
Okay. And are those the fingerprints that you took of the person you just identified in the courtroom?
Yes, I did.
Okay. And based on that card, is the person identified as Anthony Salinas?
Correct.
Okay. Did you bring some drop cards here with you today?
Yes, I did.
Okay. And I'm going to show you what's been marked as State's Exhibits numbers 36 through 42. you could briefly look through this for me.
The drug cards from my office.
Okay, and so you brought these drop cards here with you today.
Correct.
And just in case the jury doesn't remember, can you briefly describe what a drop card is?
Yeah, drug card is a sheet that gets generated, one issued from the officer. He'll do a report, arrest report, but that's a temporary report. And therefore he'll come booking, actually, when he gets booked, that's when this document gets generated. And a while back, there were cards, so they name it drop cards, so they put a print in the back of it.
And as specific as these cards are related, to each one of those exhibits contain a set of fingerprints.
Yes.
And I should be clear, not necessarily a set of fingerprints, but at least one fingerprint, correct?
Correct.
Were you able to compare on all of those exhibits? Which, forget the number on top of my head. State exhibits numbers 36 through 42. Were you able to compare the fingerprints on those drop cards with the fingerprints that you took here in the courtroom today?
Yes.
And were you able to form an opinion about whether those prints came from the same person?
Yes, exactly the same person.
And all of those exhibits, correct?
Correct.
Okay, let's go through these one by one. So I want to, you can look first at state's exhibit number 36. And let me back up for a second. Do each one of these drop cards contain a JN number?
Yes.
And what is your understanding of what a JN number is?
JN basically is the history of the charge itself. When they start the investigation, all the way when it gets booked, sentence, till the JN is closed.
So JN numbers are individual unique numbers.
Correct.
And are they ever recycled?
No, just for that particular case.
Okay. So I'm going to go through each one of these exhibits, and if we can talk about just the JNs, okay?
Sure.
So I'm going to show you what's been marked as state, or if you can look at what's been marked as state exhibit number 36. Does that relate to a JN of 1919818?
Yes.
Okay. And I'm going to show you what's been marked as state's exhibit number 28. Does state's exhibit number 28 reflect the same JN number as state's exhibit number 36?
Yes.
You can look at state's exhibit number 37. And actually go back. As well as having a JN number as a unique number, there's also the jury heard a TRN number.
Correct.
And that's like a tracking number, right?
Yeah, that's the track number we use to transmit his prints, which is his person, his prints to DPS.
Okay. And so is that a unique number as well?
Correct.
Okay. So if you look at state exhibit number 37, is the TRN number on that 92017505528?
Correct.
Okay. So if you go look at state exhibit number 29, did those TRN numbers match?
Yes.
Moving on to, if you could look at state's exhibit number 38, going back to the JN numbers, does that reflect a JN number of 1296114?
Yes.
Okay. So if you look at state's exhibit number 30 and compare it to state's exhibit number 38, do those reflect the same JN number?
Yes.
Just a moment.
Yeah.
All right. let me see.
Thank you. We could go on to state's exhibit number 39 for you. Does that reflect a JN number of 1074354?
Correct.
Okay. And if you could look at State's Exhibit number 31 and compare it to State's Exhibit number 39, it does contain the same JN number.
Yes.
Moving on to what you have in front of you, State's Exhibit number 40. Does that reflect a JN number of 638635?
Yes.
If you compare State's Exhibit number 40 to number 32 and see if those have the same JN number.
Yes.
You look at State's Exhibit number 41. The State's Exhibit number 41 reflect a JN number of 649176.
Yes.
If you compare State's Exhibit number 33 to State's Exhibit number 41, it does contain the same JN number.
Yes.
Finally, look at State's Exhibit number 42. Does that reflect a JN number of 631528?
Yes.
You could compare State's Exhibit number 42 to 34 and tell me if those reflect the same JN number.
Yes, same JN.
And again, all of these documents that I've shown you relate to a Anthony Salinas, correct?
Correct.
At this time, the state would move to admit State's Exhibits numbers 28 through 34, and I'm tendering to defense or inspection.
Objection, Your Honor.
All right, State's Exhibits 28 through 34 is admitted.
Your Honor, may I publish for the jury?
Yes.
So, Mr. Alvarez, there should be, is that screen on next to you? Is that on to your left? No, the bigger one.
No.
Is it not on? Is it? Okay. I'm gonna try to go through these as quickly as possible. I'm gonna show you what's been admitted in State's Exhibit number 28. Again, that reflects a defendant by the name of Anthony Salinas. Correct? Okay. Oh, it's flickering? Great.
That equipment does not work.
All righty, Judge.
Now, if you would like for him to step into the well.
I'll try to zoom in real quick. Reflects a defendant by the name of Anthony Salinas.
Yes.
And a judgment for the offense of violation of a bond or protective order.
Correct.
Specifically, going to go to the information on the case. Am I reading it correctly that says Denise Valdez right there?
Yes.
Safety Exhibit number 29. Again, Anthony Salinas by the defendant, correct?
Correct.
And this is, again, another judgment. Correct?
Yes.
And for the offense of possession of a controlled substance, penalty group 1, less than 1 gram.
Correct.
State's Exhibit number 30. Again, this is a judgment regarding a defendant by the name of Anthony Salinas.
Correct.
Okay, and for the offense of assault bodily injury Mary.
Yes.
Going to the information on the case. Again, I'm reading the victim's name correctly, it's Denise Valdez, correct?
Correct.
And it's alleged to happen on May 8th, 2008.
Right.
Next, I'm gonna show you what's been admitted, 34, I'm sorry, 31. I'm sorry, I'm just gonna go through all these judgments with you pretty quickly, okay?
Sure.
Again, relates to a defendant by the name of Anthony Salinas
Yes.
and judgment for the offense of resisting arrest, search, or transportation.
Correct.
And you what's been admitted, 67 number 32. Again, a judgment for a defendant by the name of Anthony Salinas
Correct.
and for the offense of violation of protective order.
Right.
Moving on to State's Exhibit number 33. Again, we see a defendant by the name of Anthony Salinas, correct?
Yes.
And it's a judgment for the offense of violation of protective order.
Correct.
And then finally, showing you what's been admitted as State's Exhibit number 34. Again, a judgment for a defendant by the name of Anthony Salinas
Yes.
and for the offense of endangering a child risk of bodily injury.
Correct.
So we can see, put these in chronological order, but the date on this one being the oldest, it would be December 21st of 1994.
Yes.
And that's the conviction date, right?
Yes.
Okay. And then go into the newest one, which would be State's Exhibit number 28. Is it fair to say that that judgment reflects January 24th of 2020?
Yes.
You aren't decided to say without witness.
Defense.
No questions, Your Honor.
All right, is this witness excused or subject to recall?
I ask that be excused.
Defense.
No objection.
All right, you're excused.
Thank you, Your Honor.
State, call your next witness.
Your Honor, at this time, the state will rise.
All right, defense.
Defense calls Amy Sanchez, Your Honor.
All right, Ms. Sanchez.
I believe she's still under oath, Your Honor.
She is. Ms. Sanchez, you're still under oath. Just have a seat, please. And if you could restate your name for the record.
Amy Sanchez.
All right, defense.
Ms. Sanchez, how long have you known Anthony Salinas?
Since he was 12 years old, so over 30 years, over 30 years.
And during that time, has he been pretty much the same kind of person?
Yes, 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 yes.
Would you describe him? What kind of person is he?
I'm not saying Anthony's an angel, no. Anthony to me is like my little brother. That's why I look at Anthony. He's been a pain in my butt, but he's my best friend. He's giving, he's loving, is he an angel? No. Has he done his fair share of mess ups? Yes. But this right here, right now, is something that I have been telling Antonio about. Please, please make reports. Anthony, what would I do like calling the cops on a woman? Who are they gonna believe? Guess what you would look like? A free man. I was so sure that Anthony was finally gonna be heard. And that this was finally gonna be seen. Me, myself, I was a victim.
Your Honor, at this time, the state's gonna object that this is narrative.
That'll be overruled.
I was a victim of domestic violence. And guess what? Anthony was there always to help me. So several times I spoke to Denise. Why? They're so scared. What I can remember every time I was speaking, every time Anthony was in trouble, every time Anthony did something wrong, because I was there yelling at Anthony, get after him, because again, you're like my little brother.
How many children does Anthony have?
Anthony has two nieces, and then he's got the three, total of five.
And is his oldest daughter here in the courtroom?
Yes.
What's her name?
Ashley.
And Ms. Benchaka is also in the court.
Yes.
Anthony has had repeated criminal events and criminal charges brought against him by Denise Valdez.
Yes, he has, and I tell you why.
Certainly.
Because when Anthony's in jail, she's with his brother. But when his brother's in jail, she's with Anthony. Because if we would look right now, she's got visits set up with his brother right now, because he's currently incarcerated.
Is this the same, when you said she was with his brother, you mean in the biblical sense, right?
Daniel Salinas, his brother, she was intimate, she was carrying on a relationship with his brother, so Anthony had to be at the door.
And this was
Every
during the
time
time when Anthony was actually married to her?
When Anthony was with Denise, every time Anthony went to jail, Denise was with Daniel Salinas, Anthony's brother. And when Anthony would come out and decide he was gonna be okay and do what he had to do, and he was starting to do okay, and she'd come around. They're so scared, why come around? I stayed away from my abuser for 30 years. It took me 30 years to be able to stand up because I was really afraid. I wanted nothing to do with that person.
Do you think anybody needs to be afraid of Anthony?
Anybody should be afraid of Anthony?
No, is there anybody who should be afraid of Anthony?
Anthony should be afraid of Anthony because Anthony is so smart. Every time he's so smart, it's stupid. Because he's a smart man. His business can take off from one day to the next. And I was telling him, go do what you gotta do. And it's right when he was getting to where he needed to be. Guess who come around? Denise.
Do you have anything else you want to tell the jury about Anthony?
I thought for sure, I kept telling Anthony, we can't lose faith, right? So this is life, right? Life for Kayla, so they're gonna see through her BS. Because it's been going on for too long. So that is. They help them to pull their lives like. But they're not good. I don't wish anyone ill, I swear, I just wish that she would be honest, that's all. That's all.
Thank
I
you.
wish she'd be honest.
Pass the witness, Charlotte.
State.
I just have a couple questions for you.
Go ahead.
So you said you've known Anthony for 30 years, right?
He was 12 years old.
So, understandably, you were in the courtroom. This obviously didn't have an objection to you being in the courtroom for the last testimony of the fingerprint examiner, right?
Right.
So you heard his testimony.
Right.
So you testified earlier on direct that said that, you said that every time Anthony went to jail, it was because of Denise.
Denise has something to do with it, yes.
Your Honor, may I approach?
Yes.
I'm going to show you what's been admitted as State Exhibit number 29. This is a judgment for the offense of possession of a controlled substance less than a gram, right?
I'm talking about the abuse, the violence, the family violence, those charges. It's been because Denise. I understand that, this, that Denise, I don't know whether she created it or not, but the abuse evaluates every time it's been, because Denise has been behind it, and when he goes to jail on those charges, there's pictures, there's Facebook posts of her, his brother.
Well, then let me show you State's Exhibit number 32, which is a violation of the protective order case, right? So you can see that he was convicted of this offense on June 29th of 1995, right?
It says, like, did he went to her house, or did he reach where she was at?
Just let me finish, I'll get to there.
Okay.
So this is what he is alleged to have done. Violated a protective order that relates to Leslie Salinas. That's not Denise Valdez, right?
No.
Okay, okay, so that, we can agree that Denise had nothing to do with this.
Right.
Okay. So, I'll show you what's been admitted in State's Exhibit number 33. This is another violation of protective order case. It's a different one. Okay, the conviction date of June 29th of 1995. And the victim on this case, where she was convicted, is again Leslie Salinas, right? Okay, so that again, this is not Denise.
No.
Alrighty, I'm going to show you what's been admitted in State's Exhibit number 34, which is a judgment for the offense of endangering a child with the risk of bodily injury. The conviction date is December 21st of 1994. And it relates to a victim by the name of Roxanne Salinas, right? You can agree Denise had nothing to do with this either, right? Okay. So we have State's Exhibit number 29, the drug case.
Right.
Okay. Can you at least agree that Denise had nothing to do with this and being in possession of drugs? Okay.
I don't know.
And we'll show you what's been in this State's Exhibit number 31. This is a judgment from October 6th of 2005 for the offense of resisting arrest, search, or transportation. You'll agree with me that the officer in this case is armed unit-less, right? And that again is not Denise.
Okay.
Right.
Absolutely right. Let me reiterate.
Well, yeah, I do. So it's fair to say that out of the out of the 7 judgments we just entered, Denise is only listed on 2 of these.
Okay.
Right? Is that fair to say?
Fair to say. So maybe, can I?
You might be able to have an opportunity to.
Go ahead.
So, you've known again Anthony for 30 years, and so you're very clear that Denise has to do with it, and that's your opinion about it, right?
Excuse me, say again?
It's your opinion that Denise, when he went to prison, was at fault for that.
On the charges that she pressed against him, it was because of her lies. Yes, that's what I said. Let me read it. Let me clarify.
Yeah.
Anytime it's come to Denise being involved, it's been because of her lies to make way for either his brother or the cousin that was before that. So that's what I was trying to make clear.
Okay. You're on approach again?
Yes.
You know that you weren't present during this portion of the testimony, so I want to get the opportunity to talk about it. So I'm going to show you what's going to be in State's Exhibit number 3. And this is a conviction regarding Anthony, right? For an aggravated assault with a deadly weapon, right? And that he was convicted of this offense, and then he was judged. The judgment was entered on July 27th of 2009, right? And this is a case involving Denise. Let me just find the name for you. Denise. Right? Okay. So you knew Anthony in 2009, correct?
Correct.
So you're aware that he went to prison for this?
No, I wasn't aware he had gone to prison at that time, but yes, after I got back in contact with him, yes, I was aware that he had gone to prison, and I was aware that at that time she was overseas.
Okay. So 2009, he goes to prison for this, right? And then he goes to prison and then he gets out, right?
Right.
And then he goes back to prison again, right?
Right.
Okay. And so I'm showing you what's been admitted to State Exhibit number 4. This is a judgment. The judgment was entered on October 27th of 2014, again involving Anthony Salinas, right?
Right.
And in this, it shows that he went to prison for 2 years, right, for the offense of assault, family second.
Right.
Okay. And just to give you the fair opportunity to talk about it, this is another case involving Denise, right?
Right.
So he goes to prison in 2009.
Right.
He gets out and he goes to prison again, right?
Right.
So am I understanding your testimony correctly today? That it's your opinion that the reason that Anthony went to prison and got jail sentences on some other cases was because Denise fabricated them so that she could have a sexual relationship with Anthony's brother?
It's not my opinion, it's my knowledge. Denise has told me this herself. She has sat in my home, where Anthony was several times. How afraid are you? How afraid is she? How afraid is she? I didn't see my abuser for 30 years because I was afraid. I stayed away. Why are you at my home if you're so afraid?
And it's not just, I'm not discounting your story. We obviously prosecute family violence cases here because we care about them, right?
Right, exactly.
And so I'm not discounting your case, but at the same time, don't you believe that Denise is a victim of domestic violence herself when her abuser's gone to prison twice already for it?
Okay, if she's a victim and she's so afraid, why continue to look for your abuser? Why? And why? I didn't look for mine because I was afraid. Because I was telling the truth when I said I would get beat black and blue.
Miss Salinas.
Miss Sanchez.
I'm sorry, I'm so sorry, Miss Sanchez.
Yes.
Are you aware that the distinction of different types of pleas, like not guilty, no contest, and guilty?
Correct.
Generally speaking.
Yes.
So I'm going to show you what's been already again admitted as State Exhibit number 3 and 4. These are the ones that we previously talked about.
Right.
You'll agree with me, right, on both of these exhibits. The plea that he took, he pled guilty.
Yes.
He wasn't saying no contest. I wasn't contesting him. He said, yes, I did these things.
Right. And you know what he said every time I told him to call the police? What are they gonna say? A man calling the police on a chick, on a woman. What are they gonna believe? And you know what? What am I gonna look like? That's what he would tell me. He would look like a man.
Your Honor, I'll pass the witness.
Defense?
No further questions, Your Honor.
All right, is this witness excused or subject to recall?
Your Honor.
We have no objection to meetings.
All right, you may step down. Defense, call your next witness.
Defense closes, Your Honor.
All right, defense, you're rested.
Rest.
All right, state closed.
Rest of those.
All right, ladies and gentlemen of the jury, you've heard all the evidence in this case. Both the state and the defense have both rested and closed, correct?
Yes, it was.
All right, what I'm going to read to you now is charge of the court on punishment. You will take this document back with you. Charge of the court on punishment. Members of the jury, the defendant Anthony Salinas has been found guilty of violation of conditions of bond in a family violence case as alleged in the indictment. The habitual offender enhancement allegation paragraph of the indictment alleges that before the commission of the offense alleged above, hereinafter styled the primary offense, on the 27th of July, 2009, and cause number 2008 CR 7919 in Bexar County, Texas, the defendant. Just one moment. The defendant was convicted of the felony of aggravated assault with a deadly weapon, and before the commission of the primary offense and after the conviction and cause number 2008 CR 7919 was final, the defendant committed the felony of assault family second offense and was convicted on the 27th day of October 2014 and cause number 2014 CR 5692 in Bexar County, Texas. To this allegation in the habitual offender enhancement paragraph of the indictment, the defendant has pleaded not true. It now becomes your duty under the law to determine whether these allegations are true or not true and to set the punishment that should be assessed against this defendant. If you believe from the evidence beyond a reasonable doubt that both of the allegations set out in the habitual offender enhancement allegation paragraph of the indictment are true, you will state in your verdict that you find true the allegations in the habitual offender enhancement allegation paragraph of the indictment and assess the punishment of the defendant at confinement in the Texas Department of Criminal Justice Institutional Division for life or for any term of not more than 99 years or less than 25 years. In addition to imprisonment, you may assess a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. If you believe beyond a reasonable doubt that only one of the allegations set out in the habitual offender enhancement allegation paragraph of the indictment are true, you will state in your verdict that you find true as to only one allegation in the habitual offender enhancement allegation paragraph of the indictment and assess the punishment of the defendant at confinement in the Texas Department of Criminal Justice Institutional Division for any term of not more than 20 years or less than 2 years. In addition to imprisonment, you may assess a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. If you do not so find beyond a reasonable doubt, or if you have a reasonable doubt thereof, you will state in your verdict that you find not true the allegations in the habitual offender enhancement paragraph of the indictment and assess the punishment of the defendant at confinement in the Texas Department of Criminal Justice Institutional Division for any term of not more than 10 years or less than 2 years. In addition to imprisonment, you may assess a fine not to exceed $10,000. And if you choose to assess a fine in addition to imprisonment, you will assess such fine and so state in your verdict. In this case, evidence has been admitted to the effect that the defendant may have committed an offense or offenses other than that for which you have convicted him. The court instructs you that you may consider this evidence, if any, in determining what sentence is appropriate in the case at hand, but you may only consider the evidence if you first believe beyond a reasonable doubt that the defendant committed this other offense or offenses. In your deliberations, you may consider evidence introduced during the guilt phase of the trial, as well as any evidence introduced at the punishment phase of the trial. Under the instructions herein given, it will not be proper for you in determining the penalty to be assessed to fix the same by lot, chance, any system of averages, or any other method than by a full, fair, and free exercise of the opinion of the individual jurors under the evidence admitted before you. The length of time for which a defendant is in prison may be reduced by the award of parole. Under the law applicable in this case, the defendant, if sentenced to a term of imprisonment, may earn early parole eligibility through the award of good conduct time. Prison authorities may award good conduct time to a prisoner who exhibits good behavior, diligence in carrying out prison work assignments, and attempts at rehabilitation. If a prisoner engages in misconduct, prison authorities may also take away all or part of any good conduct time time earned by the prisoner. Under the law applicable to this case, the defendant will not become eligible for parole until the actual time served plus any good conduct time earned equals 1/4 of the sentence imposed, or 15 years, whichever is less. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law and good conduct time may be applied to this defendant, because the application of these laws will depend on decisions made by prison and parole authorities. You may consider the existence of the parole law and good conduct time. However, you are not to consider the extent to which good conduct time may be awarded to or forfeited by this particular defendant. You are not to consider the manner in which the parole law may be applied to this particular defendant. A suitable form is attached hereto for your verdict, if you should care to use the same. However, such form is not intended to influence you in any way in arriving at your verdict. In any event, your verdict must be unanimous, in writing, and signed by your presiding juror. Respectfully submitted, Judge Stephanie Boyd, 187 District Court. Verdict forms are attached. State. All right, defense.
Thank you, Your Honor. Okay, the sentence ranges you've been given are contingent on your own action. You're not automatons. You're going to look at the case. You're going to decide what you think is an appropriate disposition of this case and this person. She's told you that if you find vote true unanimously, true for both of the enhancement allegations, the previous cases that they're saying he was charged with convicted. You vote true for both of those, then your sentence range starts at 25 years in prison, up to 99 years of life. If you vote true for one of the two enhancement paragraphs, then the sentence range is 2 to 20 years in prison. And if you vote not true for both of the allegations, the enhancement allegations, then the sentence range is 2 to 10 years in prison. Still substantial sentences on any of those three variations. I'm asking to find both of the enhancement paragraphs not true. Now, vote unanimously. Whatever your vote is, judge also told you you can't use a system of averages or lots or anything like that. It has to be your conscience, intelligence, what you think is appropriate. We're asking you to do that. We think that it is in your hands how you're going to vote and how you are going to decide to punish this man. Will you take him away from his family for a minimum of 25 years? Or would you impose a reasonable sentence for what you convicted him of?
All right, state.
Ladies and gentlemen, jury, I personally, in this case, I feel like this is probably the harder decision. I will two decisions you're going to be asked to make. First, guilt innocent, and which that will not say 3 years. Now you determine what the appropriate punishment is. And the appropriate punishment based on his criminal history, what he has done, and not any actions of other people. Right? You have to consider what he has done in this case, the situation he has put himself in. So, with verdict, no evidence in this case disproved, even from the guilt innocence phase, what would have already been admitted to states in the 3 states of Ms. Sanchez already testified she yes, he went to prison for an aggravated assault. He got out. He went back to prison for a new offense and he committed after he got out. Those are all in front of you. You have all the additional judgments in this case, ranging from 1994 up until 2020, in addition to the 2 others that he has been convicted. punishment ranging here, it starts at 25. I'm not gonna give you a number above that, but the law is that he is committed to offenses, he is a habitual offender in his past. I'm not gonna give you a number more than that, because I don't have a number for you. At the end of the day, all I ask is to come back with the unanimous verdict that you find he's a habitual offender and assess the punishment in this case that will demonstrate to him that enough is enough. You need to leave this beautiful. You need to leave everybody alone. Keep your hands to yourself. Because clearly, going to prison for 8.5 years, getting out, going to prison again for 2 years, and then again picking up another offense, violating the bond on that offense, and then committing this case wasn't. You have to assess punishment was all full off. So that starts at 25. And again, I'm not going to give you a number because we will have the arrangement special here. So we'll agree obviously whatever decision we give. But again, we ask, we find these individuals. I'm going to briefly just talk about the jury verdict form that you're going to get back there. So this is the jury verdict form. And there's
2 minutes.
Yes, Judge. There's 3 options. The first one, which is the only true verdict that you can give, and this is what I'm asking that you do, is that you find number 1 true. This is a habitual offender, because that is all that the evidence provides. As far as the number is concerned of years, I'll leave that, and I'm not going to suggest a number for you. As far as the fine is concerned, that money doesn't go in your pockets, it doesn't go in my pockets, it doesn't go in the judge's pockets, it goes into the state fund. I don't care. I don't think. I'd ask, in fact, that you just assess no fine if that is an issue that you all are contending on. I'm asking that you find that he's a habitual offender and that you assess appropriate as you see fit. Thank you.
All right, ladies and gentlemen of the jury, you have received all the evidence for the punishment phase. So I'm going to send you to the back to deliberate. And you have my permission to begin deliberation on punishment. Everyone, please rise for the jury. And Berta, we're going to take up, or do you need a break?
Can I get the citizen?
Yes.
I got a little.
Okay, no problem. All right, everyone, just give us a moment and we'll take the plea on Cristo. Nathaniel Navy.
Oh, sorry, unmuted. Okay. I conferred with Mr.
I'm sorry,
Judge.
Mr. Navy. For some reason, I cannot hear you. Just give me a moment.
Okay.
All right. Can you try now, Mr. Navy?
Yes, can you hear me now, Judge?
There's
that better?
something wrong with your volume.
Okay, let me see. Maybe I'll try logging out and then back in.
Judge, this is Amir. Can I put in a breakout room with
Just
my
for
client?
1 moment, okay?
Yes, Judge.
There's
that
something
better?
wrong with your volume. There appears to be something wrong with our volume.
Maybe I'll try logging out and then back in.
I'm just going to run up here so I can get
Judge, this is Amir. Can I put in a breakout room with my client?
1 moment, okay?
to holler. You need this.
Okay, there you go.
All
They should be
right.
able to hear you now.
Mr. Memori?
Yes, Your Honor.
All right, thank you. There's something wrong with your volume. Just give us a moment. Mr. Navy?
Yes, Your Honor. That was weird, actually. When I logged back in, I could hear myself from I guess a minute or so ago. What I was,
Okay.
thought I was going crazy, but
Or either it's a multiverse.
yeah, it must be. That's the only explanation.
All right, so who's your client?
At Simmons.
All right.
Yes, Your Honor.
All right, what is happening with Ms. Simmons?
Judge, on this case, I reviewed all the reports and the body. But there's a lot more documents that I need to go through. There's bank statements, checks, just very document intensive. And I need to go through and match up values and really go through a bit more discovery, Judge. So I'm just asking for at least another 30-day reset just for discovery purposes.
All right, Ms. Ferguson, can I have a 30-day reset in the chat box, please? All right, we're going to come back on June 21st.
Okay, June 21st. Thanks, Judge.
Yeah. Thank you. You and your client are excused.
Thank you, Your Honor. Hope you have a good afternoon.
All right, you're welcome. You too. All right, and Mr. Mamari will be with you in just a moment. The court reporter is getting exhibits together for the trial that we just completed.
And I'm ready.
Oh, you're ready? Okay. All right, who are the parties on Cristo? Who's the
Raymond
prosecutor?
Cristo, that's me, Judge. I'm here
Who's the
morning.
prosecutor?
That was with Groomer, Brian Groomer, but we haven't completed all the paperwork. I need to go back into a breakout room with him to complete the court's paperwork, Judge.
Okay, I have it as all paperwork is completed.
Okay, then it's completed, Judge.
Okay,
Okay. My
All right.
mistake. Sorry about that, Judge.
no problem.
Judge, this is Brittany. I can do it.
All right, thank you. Court is calling 2022 CR 3520, State of Texas versus Raymond Cristo. Could I have parties announced for the record for the state,
Brittany Sparks.
for the defense?
I'm here more, Your Honor.
And are you Mr. Cristo?
Yes, ma'am.
We're proceeding by video due to the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Mr. Cristo, I'm showing you what's entitled Defendants Consent to Appear by Video. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Mr. Memori, I'm showing you what's entitled Discovery Acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Cristo, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
I think so, Judge.
Yes, it appears that you are. Mr. Cristo, showing you what's entitled court admonishments. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand what you're charged with, this burglary of a building with intent to commit a theft? That's a state jail felony, and the range of punishment is up to 180 days in the state jail facility. And I'm sorry, just 1 second. All right, did you understand the range of punishment for that offense is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call them, the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I believe so, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Cristo, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page, did you review that page with your attorney? Did you understand it?
Yes, ma'am.
According to the plea bargain agreement, punishment is to be assessed at 10 months in the state jail facility. There's a $500 fine, and there are no applications. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it, and did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Then to the offenses charged in the indictment, how do you plead, Mr. Bristow? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Judge, state offer states exhibit 1 and all attachments.
Any objections?
No, Your Honor.
Mr. Christian, I'm showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call, and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Yes, Your Honor. Your Honor, at this time, I'd respectfully ask the court to give Mr. Christo the time that he's already served in credit for time served in Bexar County, and also to give him credit to allow the money and time to run concurrent, Your Honor.
All right. Court is, as previously stated, finding you guilty will sentence you to 10 months in the state jail facility, give you credit for any time served. There's a $500 fine, time and money to run concurrent. Next, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I called it your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. Do you understand?
Yes, ma'am.
If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, ma'am.
All right, good luck to you, Mr. Christo. We can go off the record. Mr. Christo, you're gonna have to start making better choices. Otherwise, you're gonna find yourself in and out of prison. Don't be the oldest person at the prison or the jail, okay?
Yes, ma'am.
All right,
Thank
good
you.
luck to you, Mr. Christo.
Thank you very much, ma'am.
You're welcome. Norma, L12 can go back.
Judge,
Thank
may I
you,
be
Mr.
excused?
Memori. Yes.
Judge, thank you I want to thank the court for its time. Thank you very much.
All right, thank you so much. Is there anyone else who's ready?
Judge, can I go into a breakout room? It's Anthony Cantrell with family violence.
All right, who's speaking? Cantrell.
Anthony Cantrell.
Okay, and you're asking for which breakout room?
Just any family violence prosecutor breakout room.
I'll send you to number 3.
Thank you.
You're welcome. Simpson?
Yes, Judge.
Yes.
The state said they need to reach out to some of the victims' relatives in my case. I think that they just took over the case. I was speaking with Marcus.
All right. And is your client in custody or on bond?
He's in custody, Your Honor. And I'm here because Jenny's in trial with Matt Allen, 226, I believe.
All right, I don't see your client. Is your client in a breakout room or no?
No, it says right there, Reno 14E.
Oh, he's listed as Reno and not Corrales. Okay.
Yes, Judge.
All right, so we were here on March 31st, and it's reset for March for the state to reach out to whomever they needed to reach out to. Just a moment. Mr. Sanders? Oh, we see you, Mr. Reno. Just give me a second. All right, how much time are you asking for to reach out to whomever you need to reach out to?
Judge, whatever you'll allow us, 2 to 4 weeks would be enough.
All right, Ms. Ferguson, on Mr. Corrales, could I have a 30-day reset? Are you going to come back on June 23rd? All right. And that will be by Zoom.
Judge.
All right, Mr. Reno, we will see you on June 23rd. And Mr. Simpson, you're excused. And Norma, that's Reno 14E.
Thank you, Judge. Have a good afternoon.
Thank you, you too. Is there anyone else who's ready?
Judge, can I update the court on my case?
Okay.
I've got Miss Allison Martinez Salcedo.
Yes.
I conferred with the state. They've made a PTD offer. We need a little time to do a couple of things they are asking us to do. We just asked for a reset.
All right, is your person listed on the screen as Samantha Saldana?
She has like reddish hair. I think she was as Allison.
Judge, Ms. Saldana is on a compliance hearing, I believe.
All right, thank you.
You're welcome.
And how's she listed on the screen?
She was listed, I think, under her own name.
Okay, because I don't see her on the screen. Did you leave her in a breakout room?
No, I left her in the main courtroom, but maybe she went into a breakout room during the trial. I was conferring with this.
Have her zoom back in, please.
Yeah, let me get in touch with her.
All right, thank you.
Thank you, Judge.
You're welcome. And everyone, just give me a moment, please. All right, Mr. All right, Lorena Rummel.
Yes, Judge. I'm with the 196 cases, and I conferred with Miguel Hernandez on a first setting of Kevin Johnson.
All right, where's Mr. Hernandez?
Mr. Hernandez, I believe, is in County Court 8 right now.
All right, we'll wait for Mr. Miguel Hernandez to be here. Ms.
Can I update the court to where we were?
Just one second. Ms. Ferguson, can you have Mr. Hernandez zoom back into the 187, please? And Mr. Stolhansky, is your client criminal trial division or family violence?
CTD. See,
I'm going to send you to breakout room number 2.
well, Your Honor, if I might, I need about 5 minutes of the court's time in a breakout when you get a chance.
All right, just give me a moment. All right, Samantha Saldana.
Yes, I'm here, Your Honor.
All right, so you're here for a compliance hearing?
Yes.
All right, so here's the thing. I know you have an issue with Scram, but you have to be on a device to monitor alcohol.
Yes.
So you're on Scram. Probation, is there anything else for her to be on?
I believe they have offered her these, I think it was the in-home device. And she, I believe, she stated she could not afford it.
All right, I'm sorry, who's speaking?
Hi, Judge, it's Danielle, sorry.
Okay. All right, so Ms. Saldana, you have to
Yes.
use the device.
Yes,
That's the
well,
facts of life.
I'm on the Scram right now and I'm not paying for the Scram, but just the only issue is I'm having violations of me tampering with it, which is what I'm not doing, but it's just, you know, sometimes the monitor is too tight around my ankle or it becomes too loose. And I'm having to go, you know, in and out just to have them adjust it every so often. But I've been on it for like 3 years already. So I've been having these problems since I've been on the Scram. And there's, you know, I can be put on another device. Only difference is I would have to, you know, come out of pocket for it. And I right now have like financial situations going on.
All right, then she's to remain on Scram. And to probation, if there's any other violation, report it, have her immediately come in to do a test for alcohol. Probation, is there anything else with regards to Ms. Saldana?
No, Your Honor, that would be it.
All right, do you need to speak with her or no?
No, if she's going to continue with Scrum, we'll let the officer know exactly what you want on her case, and she just needs to stay in contact with her officer.
All right, thank you. All right, Luz Marino.
Yes, I'm here, Your Honor.
All right. State, and I believe this is Criminal Trial Division.
You can do it, Judge.
Yes,
Brian.
She's requesting to travel to Orlando, Florida for a vacation. And the cause number is 2019 CR 1688.
1688.
And they plan on leaving December 3rd and returning on December 16th.
Yes, Your Honor.
Going to Disney World. I don't know if Disney World will still be there. There are some issues going on with that. So if Disney World is not still there and open, then of course you will not be allowed to go. But we'll see if the state has any objections.
Judge, I don't see any prior violations since she's been on probation or while she was on pretrial. I guess we'll defer to the court. We don't have an objection to that.
All right, she can go to Disney World if Disney World is open. If Disney World is not open and you all plan to do some other trip, you'll have to get permission from the court. And there's to be no driving while there. Are you planning on flying or are you all driving?
We are driving because it's going to be my whole family. We can't afford to do the airplane.
Well, here's the thing. When somebody asks you to take the wheel, you can't take the wheel. You understand?
Yes, ma'am.
All right, so probation, she's allowed to go to Disney World.
Thank you,
If it's
Judge.
open. And
Thank
yes,
you.
I do want a full panel urinalysis upon return.
Yes, ma'am.
All right, does anyone need to speak with her?
No, Judge, we will let the officer know. Just continue reporting and they'll give you your travel permit at that time.
All right, thank you so much, ma'am.
You're welcome. Gilbert Rowland.
Yes, Your Honor.
All right, there's a state, there's a request for removal of ignition interlock. Is
Your
there
Honor.
any objection?
Your Honor, I was reviewing the case. He hasn't been on probation long enough to have the device removed. He's required to keep the device on, I believe, half the term of his probation.
yes.
So he does not have the, he doesn't meet the time frame.
Okay, I don't know why this was submitted to the court. That's why I put set for compliance, because I have no idea.
Didn't
why
I
it
start
was
probation
submitted.
in 2018?
Let me see.
Yes, so he is on adjudication for 6 years.
Okay, so then,
Yes, that's half.
okay.
But so state, any objection to the removal of the ignition interlock?
So I guess the, Ms. Saldana, the corrected thing is, I guess he's made it through half.
Yes.
Judge, I guess we don't have any objection then if he's fulfilled that term of the probation, then it sounds like he's done half of his term with the ignition interlock.
All right, then ignition interlock will be removed.
Your Honor,
Yes.
my apologies. It shows that he began probation March 8th of 2019. So it would just have met the half term. Just wanted to make sure everyone knew.
All right, thank you. All right, so we will remove that. And for Mr. Roland, since that's being removed, give him 30 days of the UA hotline and let them know that there needs to be testing for alcohol. Do y'all need to speak with him?
Yes, Your Honor, if you could put him in a breakout room with me, that would be great.
Okay.
This is Officer Abrams.
Thank you. I've made you co-host.
Thank you.
And I will send him to breakout room number 1.
Thank you.
All right, the next person up is Ruth Espinoza. All right, Ms. Espinoza, it was stated that you wish to speak to me. And before you speak to me, Ms. Espinoza, let me inform you, I'm aware there are financial difficulties for everyone. But when people are on probation for driving while intoxicated 3rd or more, a device is required. You're on mute.
My apologies, Your Honor.
Yes.
I was saying that I'm totally like aware that that is definitely a necessity in my probation. Like, I agree. My inquiry was to get a hair follicle test so that I could get back on my PAM machine and off scram. So, because what happened is I had a glitch in my machine. I was good. I was blowing good until I got a new machine, and then the machine glitched and it showed that I was violating on your end when I was blowing on my end, which I have proof of in my phone. I was taking pictures of the stamp.
All right, Ms. Espinoza, let's try this before we switch different devices. So probation, if you can have help Ms. Espinoza make arrangements to have that device tested, and we'll see if there are any issues with the device. If there are issues with the device, Ms. Espinoza, you can come back the next week. I will be here, and if changes need to be made, changes will be made.
Well, Your Honor, they already put me on the scram device. So I've already returned the device back to my PAM device has already been returned, and now I'm on scram. So what I was trying to do
is here that you, in the report that I received, the supplemental report, it says that there are issues with the fee for the device.
No, ma'am, I'm not worried. Like cost, I understand that I have to pay for it, and that I'm okay with that. My deal was to be put on back on my PAM device is what I wanted, to be taken off scram and to put on back on my PAM device. All because right. It's $200 cheaper. Right. I still want to be on a device. I appreciate it. It's helped me through with my sobriety. I work at a rehab center, and I just, the PAM is just more convenient.
So like let me ask this, why were you switched from PAM to scram?
Because when I got my new machine, they issued us new machines. I turned in my old one. And then once I got the new one, it showed that I was violating when I wasn't. I was passing on my end and it was showing violation on your end. So then I went about starting to take pictures of every passing blow on my end. So I have proof that I was blowing and that I was passing on my end.
Just one moment. Allison DeLeon, are you laying in bed? I think that's a yes. Your Zoom privileges are revoked. Wherever you are, you need to come to the 187 District Court. If it's out of county, out of state, out of town, you need to come to the 187 District Court. It's located at 300 De La Rosa. It's on the 4th floor. We'll see you here.
And Judge,
Yes.
this is Albert Chidas. That's my client, Allison Salcedo or Martinez Salcedo.
Yes.
That's the girl we couldn't find earlier on the screen.
Mm-hmm.
It's a reset, Judge. I conferred with the state.
I understand, but your client needs to be here in court.
Yes, Your Honor.
All right, thank you.
Thank you.
All right, Miss Espinoza,
Yes, ma'am.
you may continue.
So essentially what happened was it showed that I was violating. I took it upon myself, like I said, to start taking pictures of all my passing blows, but she said that I would have to go, I was put on scram. And so I signed for my scram device because I'm not looking to have any issue with the court. And so I signed for my scram device, got my scram device, but it's $200 more a month. And so it really put a dent in my finances. I also work at a rehab facility now, helping other addicts with their problems. So I work in a rehab. So it looks like I did something wrong. And I it looks bad on me at my job. And I'm just concerned, ma'am. Like, I don't want to lose my job because I really like what I do.
All right,
Over
so
the fact that I have the scram device on me.
Well, I will tell you, the update I had, the supplement I had was a request with fees, not for you to go back to Pam, but probation. Is there any objections to her going back to Pam?
No, Your Honor, there's no objections.
Okay, we will do that for you, Miss Espinoza.
Thank you, Your Honor. You have no idea how much this means to me. I appreciate it.
You're welcome. Does she need to go to a breakout room to speak with anyone?
Yes, Your Honor, she could be placed in a breakout room. I'll be with her as soon as we can.
All right, I'll place her in breakout room number 2. Thanks for coming in to help out. It's appreciated.
Oh, you're no problem. I'll be here for a while.
All right, thank you. All right, Stephen Nichols.
Good afternoon, Judge.
Good afternoon. It's good to see you.
I'm glad to be seen, Your Honor.
All right, who do you have?
Alex Cuellar Sanchez.
Criminal Trial Division of Family Violence.
And I see an A Sanchez.
All right.
Here, maybe I could go to a breakout room.
Is it Criminal Trial Division or Family Violence?
No, it's trial.
All right, I'll send you to breakout room number 3.
Okay, thank you.
Matt Stohansky. And Ms. Fergus, can you see if you can get Miguel Hernandez back in here, please? Jerry Kagan.
Hi, Judge. The prosecutor this is on Valentin Ramos. The prosecutor has informed me that the arresting agency has a video that they're going to send her. We've been waiting for that for a long time.
Who are you speaking to?
I have my screen so dark, I didn't even catch her face.
It was Brittany, Judge.
It was Brittany, Judge.
All right, so when are we going to have the videos? Because we were back because there were wrong videos. First, there was videos, then there were the wrong videos on March 28th. And then on 4/26, wrong videos.
Right.
And they were supposed to be back here to take care of the wrong videos. So what is happening with these videos?
I personally had contact with the officer on this, and at 2 o'clock, he told me he's gonna make a copy and send it to the courthouse with my name on it. So however long snail mail takes these days, I will have it in my possession.
All right, Ms. Ferguson, on Valentin Ramos, can I have a 2-week reset, please?
And Judge, my only comment is I hope they send the right videos.
That's okay. We may have to do a field trip.
Yeah,
Remind me
okay.
of school.
I like that.
Okay.
Thank you. Can we be excused?
I need to give you a date.
Oh, sure.
All right, we're going to come back on June 9th.
June 9th, thank you.
Understood.
You're welcome.
You have a great day, Your Honor.
Thank you. You
Take care.
too. All right, any other defense attorney ready?
Excuse me, ma'am. Am I allowed to talk? I'm not sure about this.
Do you have an attorney?
Yeah, it's Miguel Hernandez, but do I just continue to wait here? Because I've been on the side of the road since 1:30. It's 3 o'clock now. Do I just keep waiting for him, or?
Yes, you do. You can either wait on the side of the road or you can wait in the courtroom.
This is fine. I just don't want to start driving because I drive for work, and I just don't want to start driving and then have to hurry up and jump back over. You know what I mean?
Yes, don't start driving.
Okay, thank you, ma'am.
You're welcome. Jeb Locke.
Hi, Judge. 22 CR 0694 Joaquin Alejandre.
Is he in custody or on bond?
He's on bond and he's on the Zoom. We have an agreement worked out. I wanted to see if we could recall it for a day next week that's good for the court.
How is he listed? On the
How is
Zoom?
he listed?
No, what is his name on the Zoom screen?
I thought it was his name, Alejandro, Joaquin Alejandre. Let me see. He was in the breakout room with me just a minute ago. I hope he didn't leave them. He might have left the meeting instead of leaving the breakout.
Yes, because he's not here.
That's probably what
It
happened.
looks like he's on breakout room 8.
Okay. Thank you very much, Michelle.
All right, Mr. Hernandez. What is happening with Kevin Johnson?
Yes, Your Honor. I've spoken with Ms. Reynolds regarding a possible offer. She, I believe, needs to check with her complaining witness to see if they will approve that. This is, we just got a first setting on this one. There's some information I need to check on and speak with my client regarding.
And does he only have this one case?
In the felony
Well, he
court, he
has-
only has this one case. There's a pending misdemeanor as well.
Okay. All right.
But-
Yes, Mr. Hernandez.
No, that's tied to the felony, Judge, too, both of them.
All right,
You know.
Ms. Ferguson, if I can have a 30-day reset for Mr. Johnson, please. All right, we're going to come back on June 23rd so that the state can speak to the complainants. Is there any other outstanding discovery, Mr. Hernandez?
No, Your Honor. Well, there is some I have to go see because of the nature of the discovery. I cannot see it over the I have to go to the office to look at it, but I will take care of that before that date.
All right, you and your client are excused if there's nothing else.
Thank you, Judge.
All right, you're welcome. Ms. Rommel, if you don't have anything else with us, you are excused.
Thank you, ma'am.
All right, thank you.
Judge, I have something real quick. If the
Just a
court-
moment. Yes.
On Miss Roper, we were scheduled to finish up a plea, and the DA needs to speak to the complaining witness, and we'd like a very short recess.
Where's Miss Roper? She's in the courtroom. Thank you. And how much time is the state asking for?
Judge, yeah, if we could get 2 weeks. This is one that was gonna plea. There were some issues regarding the affirmative finding as it relates to her being able to be primary managing conservator. And so I just need to speak with the victim about that specific issue.
All right, Miss Ferguson. On Miss Roper, I need a 2-week reset. All right, I'm setting it for June 9th for disposition. Ms. Ferguson, Ms. Roper is in the courtroom. Her Zoom privileges are revoked. So if you could give her a reset form, please.
Judge, can we move that to June 7th, please, then?
All right, June 7th.
Thank you, Judge.
Thank you. You're excused.
Bye.
Oh. All right, Jeb Locke.
Hi, Alejandro is in the chat. I didn't know if you could recall us to either Monday or Wednesday for plea next week.
Or is there a reason we can't do this today?
I need to go tend to my children.
Ms. Ferguson, recall Alejandro for Monday.
Will that be 9, Judge, or 1:30?
That will be 9 a.m.
Thank you very much.
and it'll be in the courtroom.
Okay, I'll be there, Judge. Thank you.
All right, Ms. Ferguson, if you can put Alejandro for Monday, the 23rd at 9 a.m. All right, you're excused. All right, is there anyone else who's ready?
Judge, I've conferred. I wasn't sure what we were supposed to do. I've been sitting in the waiting room for a while. I have a newer offer from Brittany. I'm conveying that to my client. I don't think it has been resolved yet. It's going to require some more work with that offer.
Mr. Carvajal, you need to start your video. All right, Norma. Mr. Carvajal, he only has 2 cases. Is that correct, Mr. Acevedo?
Yeah, two indictments. Yes.
All right, Ms. Ferguson, can I have a 30-day reset on Mr. Carvajal? And your client's Zoom privileges are revoked, so he's going to have to start appearing in person.
Where is he, Judge? I mean, he's been here all afternoon.
No, he's out there. He's on the Zoom screen with no video, no audio. All right, so we're going to come back on June 21st.
Yes, ma'am.
All right, and your client will need to appear in person.
I'm making a note of that right now.
All right, thank you.
May we be excused, Judge?
Yes. Matt Stohansky.
Yes, Your Honor.
All right, where's your client?
He's in jail. He's Jose A.
All right, what is happening with your case?
Your Honor, I need to speak with you in chambers with Mr. Grimmer.
All right, just give me one moment.
Yes, Your Honor.
All right, I really don't believe we need to speak in chambers. I already have a notation. So Do you need to speak with Mr. Groomer in chambers and give the court a date?
Yes, ma'am. Let me talk to him for just a minute.
All right, Mr. Groomer, if you go to breakout room number 1 with Mr. Stohansky, please. Is there anyone else who's ready? And does Stephen Nichols need Mr. Sanchez in the breakout room with him?
How you doing, Judge? Does it mind if I have a second with you?
I'm doing great. What is your name?
Henry Knight.
Who's your attorney?
Judge, I sent you, I'm sorry, Judge, I sent you a chat on that.
All right, Mr. Knight, your
Yes,
attorney's
ma'am.
in jury trial.
Yes, ma'am.
So we're going to reset your case. Ms. Ferguson, I'm going to have a date for Mr. Knight, please. Is that a jury trial date, Ms. Ferguson? Or you gave me, yes. All right, your next date is going to be May 31st. That'll be in person, Mr. Knight.
Yes, ma'am. Thank you, and you all have a blessed day.
All right, thank you too.
Yes, ma'am.
Can I ask you a question, ma'am?
Yes.
Is my attorney in there?
What is your attorney's name?
Anthony Martin Smith.
He's not here yet. He will be here. Everyone, if you're waiting on your attorneys, you're just going to have to be patient. Your attorneys will be here.
Judge Void,
Yes.
I think you had told me to go to a breakout room 3 or something with Nicholas Stephan or
Yes.
something. How do I do that?
It should pop up on your screen. Just one moment.
Okay.
Judge Boyd, the reason I asked my attorney was here or not, the last 3 times I came in court, he has not shown up.
Just wait patiently.
I'm gonna go down to stand for it.
All right, Sancho or Sanchez, who needs to be in breakout room?
Sanchez?
All right, just one moment.
Okay.
I sent you to number 3.
I got it.
You're welcome.
Thank you.
And everyone just give me one moment.
violence of chemical
All right, Matt. Okay, he's still in breakout room number 2. Matt Stohansky?
Yes, Your Honor.
Yes. Did you have a chance to confer with the state?
Yes, ma'am. Mr. Groomer, I would deeply appreciate 1 minute of your time, if you could.
All right. If you'll go to breakout room number 2, please.
Yes, ma'am.
Thank you.
Yeah, this is important.
All right, Lorraine Efron.
Is quick and easy meeting.
Lorraine
Thank you,
Efron.
Yes, yes. Thank you, Judge. Thank you. Alex Martinez, he's at the jail. He has 2 indicted cases, and Marcus Sanders and I were conferring. It appears that there's a sealed case out there. And so was going to request additional time while they try to get that information to me to determine what's going
What is
on.
the new case?
I don't know. I think it may be an ag assault or something along those lines.
That's correct, Judge. And I have been working on getting her the discovery. I just burned it to a disk. I'm going to drop it off this afternoon.
All right, Ms. Ferguson, if you can call Mr. Martinez in 1 month and state you need to be prepared to make an offer at that time.
Yes, Judge.
Judge, is Norma on the Zoom?
Yes, she is.
I don't know how to message her because I can't find her, but I need somebody to send paperwork for a plea that we have on Jonathan Trevino.
Oh, yeah, just chat her. She's listed on the Zoom as Ferguson coordinator.
I don't know why I can't find her, but I'll find her.
Ms. Ferguson, I need a 30-day reset. All right, we're coming back on June 16th.
Okay. Thanks. And did you say, oh, you want an offer made by that day?
Yes.
Okay.
All right, you and your client are excused.
Okay, thank you, Judge.
You're welcome. And Norma, Mr. Martinez can go back. He's 17B. Brian Kimbrough.
Good afternoon, Your Honor. Believe we have the paperwork in for Adam Sancho. Completed my end. My client said he completed his, so.
I mean, do we know if your client has completed his?
Well, I believe he, I haven't checked. I just got back on, but he says he sent it in, so it should be there. I don't know.
No, because I don't have it. So I'm going to send him to breakout room number 1. I'll send you to breakout room number 1.
Okay.
Mr. Sanchez, go to number 1 with your client. I mean, sorry, with your attorney. And to the clerks, if you can go to breakout room number 1, please, and see where the paperwork is. Hi, how are you doing? See you in person.
I am here. May I approach?
Yes.
We have a plea bargain worked out on Gabriel Hotline, statement and offer. We like it. I'm here if we can do the paperwork.
All
Take
right,
care of
thank you. All right, so everyone, Mr. Sawyer is in the courtroom to do the paperwork on Papua.
Yes, Judge.
All right, thank you.
It's been a crazy day so far.
Hey, you know what? It can only get better, or it could get crazier.
I just hope it'll get better.
Yeah, but either way, it'll be a great day.
There's never a bad day.
No.
Good afternoon. How are you?
Good, how are you?
Now, I guess I'll just download the paperwork to me here, or a clerk will bring out the paperwork.
Oh, they'll bring it, they'll download it to this computer in the courtroom.
Thank you.
You're welcome.
Hi, John.
Hi there. Well, I'm the designated loser again this week.
Oh. Well, our name the barrel, so to speak.
Yep.
Judge, you got all the flowers today.
Flowers always brighten the day.
Great looking.
Oh, thank you.
Forevermore.
It's actually a commentary as a result of the Vietnam War, but it's set in a science fiction future alien culture that we're for. Time compression changes how everybody views time.
They just had a program on a remake of the War of the Worlds.
Yeah.
The new one, where they're using the wormholes and black holes, and wondering how can they heard about any warnings that came through a wormhole.
So it's only a couple hundred, it's 100 million miles. You don't have to go through space and time.
Astrophysicists and the big boys with big brains are always delving in that area. So if you took a rocket as we know it today, you don't carry enough oxygen to go here and there.
All right, probation, do you know what the issue is with Mr. Perez?
Your Honor, it looks like he was placed on the felony drug court wait list.
Well, they
And-
just, felony drug court just sent an email saying that they have openings.
Technology to get there.
Okay, I did see that email you sent a little bit earlier, so I will take a look at that. The court was informed and just asked that he remained in custody for state ISF. So I'll look at the email you sent earlier and then get on it.
All right, thank you so much. Mr. Perez? You're either going to be in felony drug court or you're going to be at ISF. My understanding is there are now openings in felony drug court. So we're gonna try to get you sent over there, okay?
Yes, ma'am. Thank you very much.
You're welcome.
In Mexico.
Do you all need to speak with him?
No, Your Honor, I don't think so. Not at this time.
All right, thank you.
That's all you have. You thought that was a waste of time.
Jonathan Ross? And Mr. Charles, we're still waiting for your client to appear.
Who's the first one to break the ball?
Mr. Charles, we're still waiting for your client to appear.
And Judge, I know you called Mr. Ross's case. That one, I'm working on the paperwork right now for.
All right, thank you.
Let's tell you, it's different countries, the same background. Lack of opportunities, things got to go that way. My grandfather didn't even really know where Texas is located, so kind of a fuzzy concept. And it took my dad was 9 years old at the time, and walking and working from San Luis to the lake, it took about 1 year. Then you had to have sufficient cash to show you. Eat, work worked on the way, said somebody back support the wife of my younger sister. And they got into the radio sometime in February. And pays would bring out, there was a bunch of people down in a flatbed truck on the way to San Antonio. Winter, February, San Antonio. Where the depression, to my grandfather's the land of limited opportunity. It's ground prison, both had a job, medium, but it was a job.
Yeah, job.
And Dad was that generation. When the war broke out, the rest of the families up from Mexico lived in a little house on Nagalito Street. They were on the radar. They were not U.S. citizens. War broke out. They didn't matter. They had no chicken in that time. But yet the men and they got together Sunday night to discuss somewhere was a place called Pearl Harbor had been attacked. And this will never happen again like this. The men decided the oldest son without he's away, actually go down and involved. Yeah, no, Dad just turned 18. He was the breadwinner.
This is supposed
His
to
fair
be.
skin, he spoke good English, he had a job working.
And then you go back there.
I'm stuck, you know, so my grandpa. So, I respect my advice. Joe, we got one before he had that job. So that's, and he went straight down involved with all the oldest family. So they're all Mexican Americans. And my dad's a small man, just 5'6", and weighed 122 pounds. Little Joe. He learned early on in basic that natural back. So took guys out, and they took us out to some range where there's a Jeep. The Jeep was coming. And you're going to Jeep behind it. You want to see if you hit that kind from there. Didn't see like a big thing to him.
Mr. Kimbrough?
Waste gun, B-17.
Yes, Your Honor, we're ready.
All right, just as soon as your client is sworn in, then they give me the paperwork. Has your client been sworn in?
Yes, he has.
All right, thank you. As soon as they give me the paperwork, we'll take that up.
Yeah.
All right. And Miss, who are you? What's your name?
Oh, I'm Allison Martinez.
All right, that's your client, Mr. Charas?
Yes, Your Honor. Allison Martinez Salcedo. I conferred with the state. They had previously offered a PTD, and I realized we actually submitted it already last time we were in person. So once we hear back, we can hopefully do something next time.
All right, Ms. Ferguson, on Salcedo, Martinez Salcedo, can I have a reset for PTD update, please? All right, we're going to come back on June 23rd. And your Zoom privileges are revoked, so you're going to have to always appear in court. Do you understand?
Yes, ma'am.
Just remain here and they will give you a reset form.
Okay, thank you.
You're welcome.
And Judge, what time do you want us in on that date?
It's 9 a.m.
Thank you, Judge. May we be excused?
You can be excused, but she needs to get a reset form.
Yes,
So
Your
they'll
Honor.
give
Thank you.
one. All right. Miss Martinez,
Yes, ma'am.
if you'll go to the back of the courtroom, to the offices, yes, and go to the offices and they'll give you a reset form.
Over there around. Oh.
Yes.
Oh, okay, I'm sorry. I forgot.
No
my
problem.
glasses.
Sure. Okay. Brenda, do you see her on the docket? All right, thank you.
Ms. Boyd, can I ask a question?
Just one moment. Ms. Settle?
Yes, Your Honor.
Yes. Yes, what's happening with your case?
Oh, okay, yes. We just now finished the plea in County Court 13, so the misdemeanors have been taken care of, Judge.
All right, so, and what was going to happen with this case?
That was a condition of this plea offer that we were given. So we've also signed the paperwork for the plea in this case.
All right,
Judge, they busted already.
all right. And Ms. Settle, I'm gonna send you to a breakout room. I'm gonna send you to breakout room number 1. Where's your client?
I just spoke to her before I got on, Judge. She was going to get on. So you want me to wait for her to get on? Let me call her again.
We're gonna take a decision in the jury trial that we have.
Oh,
So,
okay.
Brenda, we're gonna take this plea and then we're gonna take the verdict.
Should I head down?
Yes. All right, court is calling 2022 CR 1747, State of Texas versus Adam Sancho. Can I have parties announced for the record for the state?
Brian Gruber for the state of Texas.
Brian Kimbrough for Mr.
For the
Sancho.
defense?
Brian Kimbrough for Mr. Sancho.
And are you Adam Sancho? You need to unmute.
Yes, ma'am.
We're proceeding by video due to the pandemic. Any objections from the state?
None from the state.
Any objections from the defense?
No, Your Honor.
Mr. Sancho, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Defense, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case and did you review it with your client?
Yes, Your Honor, I have.
I'm sorry, we didn't hear you.
Oh, yes, Your Honor, I did. Yeah.
Mr. Sancho, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Yes, Judge.
Mr. Sancho, I'm showing you what's entitled Court Admonishments. Did you review this document with your attorney? Did you understand it? Just one moment. Showing you what's entitled Court Admonishments. Did you review this document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with possession of a controlled substance penalty for one less than 1 gram? That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, if for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call in the right to remain silent?
Yes, ma'am.
All right, Mr. Sancho, you appear to be nodding off during this. Is there some issue?
I got a little baby that was crying all night, so I was just a little bit tired.
All right, if you're drug tested today, what are the results going to be? And know that you're going to get drug tested today.
I should be good.
What do you mean you should be good?
I haven't had any. I haven't been using anything for a while now.
What does it mean for a while?
This maybe about 3 months.
All right, you need to show your video.
I know the power's going low on the phone.
All right, Mr. Kimbrough, do you know if your client is able to proceed?
Excuse me, Your Honor?
Do you know if your client is able to proceed?
I believe he is. I talked to him at length today. I understand he's tired, but he's understands what's happening.
All right, do you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call against you and the right to remain silent, Mr. Sancho?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you're giving up those rights?
Yes, ma'am.
Did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Did you understand?
Yes, ma'am, I do understand.
Counsel, has your client been able to provide you with any defenses to this offense?
He has, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do, Your Honor.
Mr. Sancho, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, I am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review this page with your attorney? Did you understand it? And did you sign it in all the appropriate places? Did you review the plea bargain page with your attorney and did you understand it?
Yes, ma'am.
According to the plea bargain agreement, your fine is to be at $1,500 prorated. State recommends deferred adjudication. They will take in consideration night bag number 634752. There's restitution of $57 for laboratory testing. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
It is, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? Did you sign it in both places?
Yes, I did, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that are filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 3 years. There be a TAP evaluation and 100 hours community service restitution. Did you understand those were recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am.
Then to the offense as charged in the indictment, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Judge. State would offer state's exhibit number 1.
No
Any
objection.
objection?
No objection.
showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments, and the court will review the same. All right, it appears that when this was printed off, there's a page that's missing. I'm assuming that page is in the printer. So to the clerks, could you please bring me the page that has the lab report on it, please?
Yes, ma'am.
Judge,
All
I
right, the court
apologize.
had previously, yes.
I do see it connected. I can resend it again, Judge, but I think it should be on there.
No, it wasn't. It was still in the copy machine.
Oh, okay.
So just so the record can be clear, Mr. Kimbrough, the lab reports was in the copy machine, and the clerk says they just brought me the lab reports. So is there any objection to including the laboratory reports in States Exhibits 1 and Attachments Defense?
No objection.
All right, after reviewing States Exhibits 1 and Attachments, the court will find there is sufficient evidence to find you guilty. However, the court will defer finding of guilt as you've applied for deferred adjudication. Are you proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Well, I would ask the court to follow the plea bargain and give him 3 years deferred adjudication. He has no prior felony convictions. He is an self-employed, working, living with his parents. Believe he can complete all the probation successfully.
All right, what is the nightmare that's being taken in consideration stage?
It's also a less than a gram case, Judge.
Mr. Sancho, do you have any children? You're nodding up and down. Could you please unmute yourself and keep yourself unmuted and speak up? Do you have any children?
Yes, ma'am. I do have children.
What are their ages?
I have a 15, 14, 10, and I have a 1 month and a 2-year-old also.
Do any of these children live with you?
No, my oldest, he stays here with my mom. Yeah.
All right, so where does the 14-year-old live?
They stay with their mom,
Where does the 10-year-old live?
with his mom.
Where's the 1-month-old?
She stays with her mom.
And the 2-year-old?
she stays with her mom. I got multiple baby moms.
All right, so which child is with you at the home now?
Well, my oldest boy stays here at my mom's house, but I work a lot, so I'm in and out. And
No, my question is, what child is at the home with you right now?
my oldest boy. I was watching my baby girl
No,
last
your
night.
oldest boy didn't keep you up. Your
I was
oldest
watching-
child didn't keep you up at late last night.
Yeah, that's what I'm saying. I was watching my little girl last night. Yes, I was. But she doesn't stay with me all the time.
No. You told me that your child was in the house with you now. You told me that earlier before we took this plea. So what
Yes,
child is
yes.
in the house with you right now?
The 6 month.
All right, where did this 6-month-old child come from? Because you told me you have a 15-year-old, 14-year-old, 10-year-old, 1-month-old, and 2-year-old.
She's 6 months. I apologize, Mom. I got a 6-month-old. I got I believe she's like a month and a year and 4 months. She stays with her mom. I'm trying to work it out with my little girl, my recent baby I just had, but she stays with her mom sometimes, and she'll stay here with me. So I'm trying to work it out with her though.
Where are you working?
I do automotive, and I do like mobile service. So I also have like a flatbed that I tow cars out. So
All right,
Self-employed, Your Honor.
this is what the court is going to do. 3 years deferred adjudication, $1,500 fine probated. Take in consideration NIMAG number 634752. $57 to San Antonio Police Department for laboratory testing. 100 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. That's the full regimen. The court is not requiring you to obtain that, but if you've obtained that and you have proof of that, 40 hours will be taken off. Ryan Groomer, please do not injure yourself with those scissors. That's very dangerous. Field visits beginning on May 20th, 2022. The UA hotline. So probation, I'm gonna want to field visits tomorrow. I need to see if there are children at his house. There should be no unsupervised contact with minors, parenting classes. If you complete your parenting classes, then the remainder of your community service hours will be waived. Proof of employment within 30 days, no employment as a home healthcare provider with minors. And we're going to do regular reporting in person or by Zoom. And we're going to do outpatient treatment with probation. Probation, is there anything else that Mr. Sancho needs?
Your Honor, can you just verify the UA sanction that you said, please?
Oh, he's doing the UA hotline.
Thank you. No, Your Honor, I believe you checked off all of my boxes.
All right, Mr. Sancho, is there anything else you need from the court in order to be successful?
No, ma'am.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, ma'am.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am.
All right, Mr. Sancho, good luck to you. You had better stay off of drugs because one, you can't be a good parent if you're using drugs. You understand?
Understand.
All right, I'm going to send you to breakout room number 2. Probation will go over conditions with you. Mr. Kimbrough, you can go to number 2 or you can be excused.
Judge, real quick, did you order a TAP evaluation? I didn't hear that. I know you ordered the outpatient, but in order to do the outpatient through probation, he'll need the TAP evaluation.
All right, yes, then make it so, number 1.
Thank you.
You're welcome.
I had a question, Your Honor, clarify.
Yes,
You said that he, contact with minors supervised, including his own children?
yes.
So how can that be?
He can only have supervised contact with his children.
Okay. And that, so if we wanted to modify that at a later date, we'd have to file a motion?
Yes,
Okay.
but Mr. Kimbrough, your client has what appears to be a substance abuse problem. He would not be a good babysitter for his children or anyone else's. He doesn't even know the ages of his children. And when we first started on this Zoom, before I took the plea, he said that there was a child with him in that home. Now he's saying there isn't a child with him in that home. Then he says, no, it's my 15-year-old. And he told us prior that a child kept him up late last night, and he was saying that's the child that he has there. Now he's saying it's a 15-year-old. And then now it turns out the 15-year-old is not there. So we're going to go to breakout room number 2. Mr. Sancho, you would not be a good babysitter.
I'm not gonna argue with you, ma'am.
Thank you. So go to
I know
breakout
what
room
kind of
number 2.
father I am. I know what kind of father I am.
Mr. Sancho, let me ask you a question. And I want you to be honest with me. If you needed a babysitter, and let's just say I apply for the position, you check my references are great. I'm the Black Mary Poppins. Everybody thinks I'm fantastic. I work with your children. You give me a test run with your children love me. I'm singing songs. I'm doing it all. I'm teaching them everything. On paper and in person, I seem the best babysitter possible. And you say, Stephanie Boyd, I'm going to hire you to take care of my children. And I'm like, great. And as I'm walking out the door, I say, wait a minute, let me just tell you something though. I did use meth last night. Are you still going to say, Stephanie Boyd, you can babysit my children? I think the answer to that will be no. If the answer to that is yes, then we have an even bigger problem. Do you understand?
I understand.
So I'm going to send you to breakout room number 2. They're going to go over conditions with you, okay?
That's fine. You have a
Thank
great
you.
day.
Go to breakout room number 2. Have a great rest of your day.
Thank you, Your Honor.
And probation, you can go to breakout room number 2. And everyone else, I'm going to put you in the waiting room briefly. Ms. Settle, I'll put you and your client in a breakout room, but I'm going to take the sentence from the jury, and then I will bring everybody back. So Ms. Settle, I'm moving you and your client to number 4.
All right, thank you, Judge.
You're welcome. And everyone, we will bring you back from the waiting room. So just be patient. Mr. Stolhansky, is your client with you or not?
My client is 87 Jose A in jail.
All right, I'm going to put him in breakout room number 5. And if you'll go to number 5, Mr. Stolhansky.
Yes, ma'am.
And I'm trying to find 187 Jose. Oh, there we go. If you go to number 5, Mr. Jose, and we'll bring you out when we're ready. All right, just one moment. Mr. Jose, if you go to breakout room number 5, please. If you look at the bottom of your screen, you'll see where it says participants. There should be 4 squares. Do you see that at the bottom?
No, ma'am.
All right. Is there a deputy in the room with you?
No, let me go get one.
No, don't move because they don't like people to move around. I want you to look at your screen and tell me if something pops up. A request, do you see a request to go to a breakout room?
No, ma'am.
All right, I'm gonna put you in the waiting room and we'll bring you back, okay?
Okay, no problem, ma'am.
Judge, there's a deputy on their way.
Okay.
Yeah. You like right click on Ryan Boomer. And then put non-video participants and non.
Mr. Jose, go to number 5.
Oh, it's because he's high. Oh, he's 10. No, go back down where you were at. And just hide.
I did it.
Oh, it says he's 10, Judge.
Oh, who's 10?
Ryan, you just unpin him. Oh, we can't unpin him.
Oh, here we go. So you should be able to unpin it now.
Right click it. There we go.
Okay.
And then put the other screen, please. There we go.
Okay. And we're ready to bring them in.
There we go.
Yes, thank you.
All right, jury.
Time out, that's okay.
Ready?
Yes.
All right, for the jury.
All right, everyone, please be seated. Actually, there's been some major changes in seat position on the front row. All right, ladies and gentlemen, I've been informed by the deputy that you've reached a verdict as to punishment. Is that correct?
Yes.
All right, is it unanimous? All right, deputy, if you could bring that to me, please. Thank you. All right, defendant, could please rise. It states, we find both allegations contained in the habitual offender enhancement paragraph of the indictment true. We therefore assess his punishment and confinement in the institutional division of the Texas Department of Criminal Justice for a term of 33 years. In addition, we assess no fine. Would you wish to have the jury poll?
Yes, Your Honor.
All right, ladies and gentlemen, the jury, as I point to you, could you please let me know if this is, you may be seated. All right. All right, ladies and gentlemen, as I point to you, if you could let me know if this is your verdict. All right, is this your verdict, sir? Is this your verdict?
Yes.
Is this your verdict? Is this your verdict?
Yes.
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 Is this your verdict? Is this your verdict? Is this your verdict?
Yes.
Is this your verdict?
Yes.
Is this your verdict?
Yes.
All right, ladies and gentlemen, thank you so much for your service. I'm going to send you to the back and I'll meet you back there, but you may now discuss this case with anyone you wish to discuss the case with, okay? All right, everyone, please rise for the jurors. All right, everyone, please be seated. Mr. Salinas, I'm sorry, Deputy McKay, just 1 second. Mr. Salinas, your sentence in this case will be 33 years in the prison, and there's no fine. Do you understand?
What?
There's no fine. Do you understand? All right, I need a trial court certification form for him.
I thought we submitted for him.
There is not one submitted. Mr. Salinas, the form that your attorney is filling out is called a trial court certification of defendant's right to appeal form. You do have a right to appeal as this was a jury trial. Do you understand?
Yes, ma'am.
All right, do you have any questions?
If I appeal it, do I gotta stay in the county? Or can I go to TGC? And
Oh, your attorney will discuss that with you, and your attorney, either this will be your attorney for appeal, or either you will have another attorney appointed to you for appeal. Do you understand?
Yes,
All right. Oh, if I can have that to sign it.
Caroline,
Yes.
I don't remember doing the cert.
Oh, okay. Is it in y'all's email at all?
I didn't see it. Hold
Okay, I'll ask Norma about it.
on. All right. All right. We did this one.
Hey, can you do me a favor at your house? Go on my dresser, those folders that are sitting there. They're labeled, one's labeled, 1, 3, 1. I can't remember. Anyway, in the top stack of papers in one of them, there's an Aurora.
You could just close all those, I just try to waste time, not waste time like that. trying to-
All right, Mr. Kritzman.
Yes.
All right, Mr. Kritzman, my understanding is your attorney is not here today, so we've appointed a new attorney to represent you. That's Carl Alexander. I'm going to give you a chance to meet him. I want you to know that nothing is going to happen today because he's going to need to get up to speed on your case. You understand?
Yes, ma'am.
All right, so Ms. Ferguson, on Kritzman, can I get a 30-day reset? And Mr. Alexander, if you want to come back before then, you can ask to be brought back before then.
Certainly, Judge. Thank you.
And Mr. Alexander, your client has 3 cases.
Okay, are they 701 or CTD, Judge?
They are, let's see. They're all CTD.
Okay, thank you,
And
Judge.
one appears to be a 1st-degree felony, and the others appear to be 3rd degree and 2nd degree.
Okay.
Can I talk to him in a break room?
Yes, I will get you there. Just give me a moment. Ms. Ferguson, can I have a 30-day reset on Mr. Chrisman, please? All right, we're going to come back on June 23rd. Mr. Alexander, when you finish speaking to your client, if you can just have him come back to the main room, and I'm going to send you both to breakout room number 1.
All right, thank you, Judge.
You're welcome.
So discover acknowledgement. You have to walk me through this. Second.
Oh, I didn't love you. Right back. Let's meet open. Right back.
Well, right now, it's just a learning curve for me.
All right, no problem.
Or, I mean, I think I'm fine with this, done with it. Which one's so bad? No. Oh, hold on, it's just that we're having.
It's just-
Oh, I should have, have they already left? I should have told them that. Usually nothing happens.
And she said other people need to hear you. I'm gonna have another, and I'm gonna co-host.
Oh, you want to make it a co-host?
Yes, please, please, a little bit down.
All right, a co-host for the courtroom?
Yes.
Well, no, there's no security.
And they're retained. What is your client?
All right, who are the parties on Trevino? Hi,
It's me, Judge. I don't know, is it okay if I do the plea here?
yes. Who's the defense attorney on Trevino?
Jonathan Rules.
All right. Are we ready on Alvarado? I'm talking too much.
I believe so, Judge.
Yes.
All right. And Ms. Ferguson, if you can put a date for sentencing on Mr. Alvarado in the chat box, please. Court is calling 2022 CR 2951, State of Texas versus Jose Alvarado. Could I have parties announced for the record for the state?
Ryan Grimmer for the state of Texas.
For the
Matt
defense?
Stohansky for Mr. Alvarado.
And are you Mr. Alvarado?
Yes, ma'am.
You're proceeding by video due to the pandemic. Any objection from the state?
None from the state.
Any objection from the defense?
None from the defense, Your Honor.
Mr. Alvarado, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, ma'am.
Court will find that the defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Next, Mr. Alvarado, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, I believe there's multiple counts. We would proceed on count 1, which is possession with intent to deliver 4 to 200, and we would waive the enhancement allegations, both of them.
Any objection to the enhancement allegation waiver?
No, Your Honor.
Any objection to the waivers?
No, Your Honor.
All right, and to the probation, this is not for probation. All right, Mr. Alvarado, I'm going to show you what's entitled Court Admonishments and Defendants Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand that you're charged with in count 1, possession with intent to deliver a controlled substance, penalty group 1, 4 to 200 grams, which is a first-degree felony? The range of punishment is anywhere from 5 to 99 years or life in the prison and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call them the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea, you are giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, ma'am.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent, was legally sane at the time of the offense?
Absolutely so, Your Honor.
Mr. Alvarado, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes, ma'am.
Court will find the defendant has knowingly and voluntarily waived his right to jury trial. Did you review the plea bargain page with your attorney? Did you understand it?
Yes, ma'am.
Mr. Alvarado, did you understand it?
Yes, ma'am. Yes,
You
ma'am.
understand the state is proceeding on count one. They're asking that your punishment be assessed at 10 years in the prison. There's a $500 fine and there are no applications. The state is taking into consideration 2022 CR 2952B and 2022 CR 2953A. Did you understand that to be the plea bargain agreement?
Yes, ma'am.
Defense, is that the plea bargain agreement?
That is a plea bargain agreement, Your Honor.
State, is that the plea bargain agreement?
Yes, Judge.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it and did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, have there been any such motions?
No, ma'am.
Then to the offense as charged in count one, how do you plead? Guilty, not guilty, or no contest?
Guilty.
State any evidence to support the defendant's guilty plea.
Judge State would offer State's Exhibit number 1 and all attachments.
Your Honor, I've reviewed my client. We have no objection.
All right, Mr. Alvarado, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Sorry?
Yes, ma'am.
All right. Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there'll be no live testimony? Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty, and the court will find you guilty, and this will be set for another date for sentencing. Is there anything else from either side?
Yes, Your Honor, I have a motion to reduce bond on file.
All right, as soon as the court receives that, the court, if you all both have an agreement, then the court will sign that. All right, is there anything else?
It should be in your box. Yes, ma'am. Okay,
All right, thank you.
thank you.
All right, Ms. Ferguson, Mr. Jose Alvarado can go back.
Am I dismissed, Your Honor?
Yes.
Thank you.
Your Honor, this is Danielle, sorry. Mr. Bettis is still here. I believe he was the one that was gonna be accepted into drug court.
Yes.
I don't think he was told he could leave, so we want to tell him he can go ahead and go.
All right, thank you. Norman, can you let them know that Mr. Perez can leave?
Thank you, Judge.
You're welcome.
Okay, you can hear me okay, right? Yes, sir. And you've done. Pages right there.
Who are the parties on Trevino?
Three on the other, concurrent.
Ms. Ferguson, can you have Jonathan Ross please come back with his client? Yes, Mr. Guzman.
Was Mr. Mauer gonna ever come back, or like, well, am I done?
Yes, you're scheduled for jury trial on August 30th.
I know, ma'am, but we were supposed to do a motion today or something, a motion hearing or something. I think the bond or something.
We'll see if we can find Mr. Mauer. Just give me a moment. Mr. Nichols?
Hello, Your Honor.
So I'm not quite sure.
I just need to visit with
Situations.
an assistant DA.
All right, just one moment. All right, let me see you to a breakout room, Mr. Nichols.
Okay.
Mr. Nichols,
Yes, ma'am.
if you'll go to breakout room, number 5, a prosecutor from Criminal Trial Division will meet you there.
Okay, number 5, there we go.
Yes.
So just waiting for, I believe you need to sign. Did you sign the consent?
Gabriel, did you sign that consent to appear on Zoom?
Okay, he did sign the plea packet.
The plea packet, Zoom, there's an agreement, ask the deputy to help you. There's one that's an agreement to appear by Zoom. You have to sign that one. That's all that's. He'll help you out. He'll be happy to see you go. That's why. On top of the paper, say consent to Zoom. Gabriel says it's already signed.
Okay.
Okay, Gabriel.
All right, and the clerk will come to that breakout room to go over the paperwork.
Gabriel, when you talk to the judge, answer, yes, Your Honor, no, Your Honor, okay? You know, we're on Zoom, it's just like we're really in the court, okay? Same rules apply. Figure, there's no jury out there, but I'm worried a couple of times.
And they'll be able to hear you through Zoom, through this Zoom.
Oh, okay.
So we're good. Oh, no.
Mr. Martinez, who is your attorney?
Ms. Efron, Lorraine Efron?
All right, just one moment.
Thank you, Your Honor.
Oh. I was just thinking about that.
All right, Mr. Alex Martinez, we're coming back on June 6th for your case. All right, thank you.
Your Honor,
Yes,
I think Mr. Martinez walked away. You said Mr. Sanchez was going to be reset to the 6th, correct?
no, Alex Martinez, that's Lorraine Efron.
Okay,
Alex
yes, yes, yes.
Martinez has other cases, and he has a sealed case. All right, thanks.
Sorry.
No problem. No, Mr. Sanchez is still in breakout room number 3. And Ms. Fergus, can you see where Mr. Ross is, please?
Yes, he should be logging in, Judge, again.
And Mr. Guzman, your attorney says that he's going to make arrangements. So Norma, Mr. Guzman, 14C can go back.
Yes, ma'am.
All right, and where is Mr. Trevino?
Your Honor, I just gave him a ring. I apologize. I thought we were reset. I just gave him a ring. He should be signing on directly.
Yes.
This is just his other case. Thank you.
You're welcome.
I'll be right back up.
Sure. All right, are you Mr. Trevino?
Yes, ma'am.
All right, is there a prosecutor available? Oh, thank you. Court is calling 2020 CR 0498 State of Texas versus Matthew Trevino. Can I have parties announced for the record for the state?
Michael Villarreal for the state.
For the defense?
Jonathan Ross for the defense, Your Honor.
And are you Mr. Trevino?
Yes, ma'am. Yes, Your Honor.
Purchasing a video due to the pandemic. Any objection from the state or the defense?
No, Your Honor.
No, Your Honor.
Mr. Trevino, I'm showing you what's entitled. Can I have the 187 video? All right, Mr. Trevino, I'm showing you what's entitled Defendants consent to appear by video conference. Did you review that document with your attorney? Did you understand it, and did you electronically sign it?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Trevino, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that document with your attorney? Did you understand it, and did you sign it?
Yes, Your Honor.
Next, I'm showing you what's entitled True Bill of Indictment. Did you review that document with your attorney? Did you understand it?
Yes, Your Honor.
Counsel, do you waive the reading of the indictment?
We would, Your Honor.
State, are you proceeding on the indictment as presented?
No, Your Honor, the state's proceeding on a lesser included offense of assault causing bodily injury to a family member or household member.
Any objections?
None, Your Honor.
Mr. Trevino, I'm showing you what's entitled Court's Admonishment and Defendant's Waivers and Affidavit of Admonitions. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Did you understand that the state is proceeding on the lesser included offense of assault bodily injury, family or household as a Class A misdemeanor? The range of punishment is up to 1 year in the Bexar County Jail and up to a $4,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you, and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you are giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to this offense?
Yes, Your Honor, very well.
Do you believe he has a rational as well as a factual understanding of the charges against him?
I do, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Mr. Trevino, did you understand that the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty, not grant you community supervision, and sentence you up to 1 year in the Bexar County Jail and up to a $4,000 fine? Did you understand?
Yes, Your Honor.
Mr. Trevino, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement, the state is proceeding on the lesser included offense of assault, bodily injury, family, or household. Fine is to be at $750. State recommends deferred adjudication. There's an affirmative finding of family violence. Did you understand with an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition?
Yes, Your Honor.
Did you understand with an affirmative finding of family violence, you're not allowed to be designated as primary custodial parent?
Yes, Your Honor.
Did you understand that to be the entirety of your plea bargain agreement?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
It is, Your Honor.
State, is that the plea bargain agreement?
Yes, Your Honor.
Next, I'm showing you the paragraph entitled Waiver of Appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places electronically?
Yes, Your Honor.
Again, did you understand you have a right? I'm sorry, just 1 second. I'm doing 4 things at one time. Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, Your Honor.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your community supervision be for a term of 2 years. There be 80 hours community service restitution, no contact with Destiny Trevino, hostility and aggression control course, and no firearm possession. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, Your Honor.
Then to the lesser included offense, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
Yes, Your Honor. At this time, state offers states exhibit number 1 and its attachments.
Any objection?
No objection, Your Honor.
Mr. Trevino, I'm showing you what's entitled Waiver and Consent to Stipulation of Testimony and Stipulations. Did you review that document with your attorney? Did you understand it? Did you electronically sign it in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments are reviewed the same. All right, after reviewing states exhibits 1 and attachments, the court will find there's sufficient evidence to find you guilty. How the court will defer finding you guilty as you applied for deferred adjudication. Are you proceeding with sentencing?
We
Yes,
would,
Your
Your Honor.
Honor.
All right, anything you wish to say on behalf of your client?
We would just ask the court to follow the plea bargain with the state, Your Honor.
All right, Mr. Trevino, anything you wish to say?
No, Your Honor.
All right, Mr. Trevino, why are you getting into physical altercation with your sister?
I don't know, Your Honor.
How old are you?
I am 23 years old.
How old is your sister?
I believe she is 24.
All right, you shouldn't put your hands on your sister in anger, you understand?
Yes, ma'am. Yes, Your Honor.
Are you employed?
Yes, Your Honor.
What do you do?
I work at Home Depot. I put up merchandise for Home Depot.
Do you have any children?
No, Your Honor.
When's the last time you had contact with your sister?
That day, Your Honor.
Who do you live with?
I live with my dad, Your Honor.
All right, this is what the court is going to do. A $750 fine and be probated, 2 years deferred adjudication, affirmative finding of family violence, 80 hours of community service restitution. 40 of those hours will be waived if you provide proof of the COVID vaccination. The court is not requiring you to get the vaccination, but if you do, 40 of those hours will be waived. There's to be no contact with Destiny Trevino. The court will reconsider that after he has completed the hostility and aggression control course, which I'm ordering. And there's to be no firearm possession, random UAs, or the patch, regular reporting by Zoom or in person, field visits, 1 time per month. Is there anything else from either side with regards to sentencing, state,
Nothing from the state.
defense,
Nothing for the defense, Your Honor.
probation? Is there anything else that Mr. Trevino needs?
No, Your Honor. The proof of employment.
Thank you. There's to be proof of employment within 15 days. There's to be no employment as a home health care provider or with minors. Mr. Trevino, do you need anything else from the court in order to be successful?
No, Your Honor.
All right, Mr. Trevino, I'm showing you what's entitled Trial Court Certification of Defendants' Rights to Appeal. Did you review that document with your attorney? Did you understand it and did you sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Because this is an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you need to know the definition of a weapon or ammunition, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, good luck to you, Mr. Trevino. We can go off the record. Mr. Trevino, you should not be putting your hands on anyone in anger, most definitely not your sister. Do you understand?
Yes, Your Honor. I'll never do it again. I'm sorry.
All right, you owe her an apology for that, but since I have a no contact order in place, you can just work on your apology letter. And by the time you finish your hostility and aggression course, hopefully that letter will be a work of art. You understand?
Yes, Your Honor.
All right, I'm going to send you to breakout room number 1. Probation will go over conditions with you.
Yes, Your Honor.
Thank you.
Thank you.
Thank you very much, Your Honor.
You're welcome. Mr. Nichols. Nicholas, what is happening with your client?
Yes, ma'am. Well, on the new number 1 allegation, there's not enough discovery to from me to make heads or tails of it. So if we could just reset the case and
Judge,
I
yeah.
can go ahead, Marcus.
Judge, there's a new number one. There's a note in the system that says there should be a prosecution guide, but there's nothing uploaded other than the warrant. If we could have just a short recess so that I can get that, I think it's one that we're going to be able to resolve. But whether that new number one is a good case or not will affect how we're able to resolve it.
All right, Ms. Ferguson, on Mr. Alex Sanchez, can I have a 2-week reset, please? All right, we'll come back on June 7th.
Sounds good, Judge.
Thank you. Have a good one.
Okay, you too. Thank you,
Sure.
Marcus.
Yes, sir.
June 7th.
All right, Mr. Sanchez, we'll see you back on June 7th.
Yes, ma'am. Okay, that's it.
Yes.
Okay, bye, Ms. Judge Boyd.
Bye-bye.
Bye.
Have a good one.
You too.
All right, so guys, the last one we're waiting on is Pat Lund.
And Judge, I think there was paperwork being done on, unless I missed it, Beth Settles.
Oh, okay.
Yeah, I'm just waiting on the discovery for that case. I emailed Brittany. She was doing the paperwork on it. I don't know. I don't see her on here. And then for Patland, Marcus, does he have the plea for the second case for the 2008 case? Because
Let me-
Mr. Sawyer already signed it.
Let me check where it's at. And then Brittany is no longer on Zoom, so I may have to do discovery again on Beth's case.
And if everybody wants to be here till midnight, let me know so I'll know if I need to order anything for the people.
I just asked my boss if it was okay if I put my PJs on after 6 on Zoom. He was like,
But nobody is allowed to leave. We must all stay here.
I was never here. Have a good weekend. Thank
So
you very much.
on Pat
All right,
Lynn,
have a good weekend. Oh, Michael is serious. He's leaving you guys.
Rude.
Your cases are done.
Yeah, I'm sorry. I mean, if I could help, I would, but I just would be useless here, so. So I'm going, bye.
All right, bye-bye. Have a good weekend.
You too.
Pat Lynn, you still need to sign the paperwork on one of the cases. Michael, are you able to go in a breakout room with your client? There's one.
Marcus, I think I just got it.
What do they need them in the breakout room or not? Okay. And look, I need to look on my signature.
I just finished signing a paper. I don't know if I have to sign another one.
Okay.
Let me see if I have anything in my box. Brenna?
Yes.
Never let it be said that the 187 does not work hard.
Oh, no, I make sure to tell everybody. that I work really hard.
All right, I just received the remaining packet from Pat Lund, so it should be going through.
I'll send it to you.
Okay.
Marcus, if you get that discovery for that Garcia case, if you can send it to Norma, because my computer's about to restart in 8 minutes.
Filter on Snapchat.
Okay. You're gonna have to send that to me.
I did.
Okay, I'm gonna look at it.
Yes, ma'am. And everything got signed. There's one that just got here, no?
Judge, I'm learning something today.
Hey.
What it looks like from this side looking out.
Brenda, this will be 2. All right, the court is calling 2022 CR 2008 and 2007. Could I have parties announced for the record for the state,
Marcus Sanders.
for the defense?
Michael J. Sawyer.
And are you Mr. Patline?
Yes, ma'am.
We're proceeding by video due to the pandemic. Any objection from the state?
No objection.
Any objection from the defense?
No, Your Honor.
Mr. Patline, in each of these cause numbers, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review those documents with your attorney? Did you understand them, and did you electronically sign them?
Yes, Your Honor.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily consented to appear by. Have you received all the discovery in each of these causes, and did you review that discovery with your client?
Sure did, Your Honor.
Then in each of the cause numbers, the court will find that the state is in compliance with discovery. Mr. Patline, in each of the cause numbers, I'm showing you what's entitled True Bill of Indictment. Did you review those documents with your attorney? Did you understand them?
Yes, Your Honor.
Mr. Patline?
Yes, Your Honor.
Oh, no, I hear you. Just 1 second, please. All right, then in each of the cause numbers, counsel, do you waive the reading of the indictment?
We do, Your Honor.
Stating cause number 2022 CR 2007, are you proceeding on the indictment as presented?
Yes, Judge.
All right, and are you proceeding on the indictment as presented in cause number 2022 CR 2008?
Yes, Your Honor.
Mr. Patline, I'm showing you what's entitled Court Admonishments and Defendants Waivers and Affidavit and Admonitions in each of these cause numbers. Did you review those with your attorney? Did you understand them?
Yes, Your Honor.
Then in cause number 2022 CR 2007, you're charged with the offense of burglary of a building with intent to commit theft. That's a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to $10,000 fine. And cause number 2022 CR 2008, you're charged with possession of a controlled substance, penalty group 1, 4 to 200 grams. That's a second-degree felony. The range of punishment is anywhere from 2 to 20 years in prison and up to $10,000 fine. Did you understand?
Yes, Your Honor.
Did you understand if you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand in each of these cause numbers, you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call and the right to remain silent?
Yes, Your Honor.
Did you understand by entering a plea bargain agreement, you were giving up those rights?
Yes, Your Honor.
And did you intend to give up those rights and enter into plea bargain agreements in each of these cause numbers?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses to these offense?
Yes, he has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Patline, has anyone threatened you, coerced you, or placed you in fear to get you to enter these pleas?
No, Your Honor.
Has anyone promised you anything other than the plea bargain agreement to get you to enter these pleas?
No, Your Honor.
Are you satisfied with the way you've been represented?
Yes, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
In each of the cause numbers, the court will find that defendant has knowingly and voluntarily waived his right to jury trial. In each of the cause numbers, I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea bargain agreement in 2022 CR 2007, your punishment is to be assessed at 1 year in the state jail facility. There are no applications, and it will run concurrent with 2022 CR 2008. In 2022 CR 2008, your punishment is to be assessed at 3 years in the prison. There are no applications, and it is to run concurrent with 2022 CR 2007. Did you understand that to be the plea bargain agreements in each of these cause numbers?
Yes, Your Honor.
Defense, is that the plea bargain agreement?
It is.
State, is that the plea bargain agreement?
Yes, Judge.
In each of the cause numbers, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you sign it in both places?
Yes, Your Honor, I did.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon. Did you understand?
Yes, Your Honor.
Counsel, are there been any such motions?
Filed under law.
Then Mr. Patlon, in cause number 2022 CR 2007, how do you plead? Guilty, not guilty, or no contest?
Guilty.
And in cause number 2022 CR 2008, how do you plead? Guilty, not guilty, or no contest?
Guilty.
All right, state in either of those cause numbers, is there any evidence to support the defendant's plea?
Yes, the state offers State's Exhibit 1 and its attachments for each case.
Any objection?
Defense has no objection, Your Honor.
Mr. Patlon, in each of these cause numbers, I'm showing you what's entitled waiver and consent to stipulation of testimony and stipulations. Did you review those documents with your attorney? Did you understand them? And did you electronically sign them in all the appropriate places?
Yes, Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes, Your Honor.
Then each of the cause numbers, the court will find the defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. The court will accept into evidence State's Exhibits 1 and attachments. And if the court has not said it before, the court is finding that the defendant has knowingly and voluntarily waived his right to jury trial. All right, the court will review State's Exhibits 1 and attachments for sufficiency of the evidence. All right, after reviewing State's Exhibits 1 and attached, just a moment, please. All right, after reviewing State's Exhibits 1 and attachments in each cause numbers, the court will find there's sufficient evidence to find you guilty in each cause number, and the court will find you guilty. Are you proceeding with sentencing?
We are.
Anything you wish to say on behalf of your client?
Your Honor, I believe everything the court needs to aid in making decisions before the court. Thank you.
Okay. In cause number 2022 CR 2007, the court, as previously stated, has found you guilty. The court will sentence you to 1 year in the state jail facility, give you credit for any time served. This will run concurrent with 2022 CR 2008. And in cause number 2022 CR 2008, as previously stated, the court is finding there is sufficient evidence to find you guilty. The court is finding you guilty. The court is sentencing you to 3 years in the prison, give you credit for any time served. This will run concurrent with 2022 CR 2007. In each of these cause numbers, I'm showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that document with your attorney? Did you understand it? And did you electronically sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waive your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, Your Honor.
And because these are felony convictions, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, Mr. Patlon, good luck to you.
All right, thank you, Your Honor.
All right, thank you. Have a great rest of your day, and
All right.
do better,
Have a
Mr.
blessing.
Patlon, okay?
You have a blessing.
All right, thank you. You too. Bye-bye. Thank you, Mr. Sawyer. It's always great seeing you.
It's always good being your court judge.
Oh, thank
I
you.
like everybody here,
Oh, thanks.
especially those that show me how to use these things because I'm computer illiterate. My secretary's in the process of trying to show me how to do all this.
Okay, awesome.
She says I'm an old dog, but I'm not learning new tricks. She can't tell
Oh,
me.
there you go.
Have a good day.
All right, you two. The court is calling 2022 CR 2514, State of Texas versus Deja Garcia. Could I have parties announced for the record for the state?
Mark Gerber for the state of Texas.
For the defense?
Elizabeth Settle for the defense.
All right, and are you Miss Garcia?
Yes, ma'am.
We're proceeding by video due to the pandemic. Any objection from the state or the defense?
No, Your Honor. No, ma'am.
None from the state, sorry, Judge.
All right. Ms. Garcia, I'm showing you what's entitled Defendant's Consent to Appear by Video. Did you review that with your attorney? Did you understand it?
Yes.
And did you electronically sign it?
Yes.
Court will find that defendant has knowingly and voluntarily consented to appear by video. Counsel, I'm showing you the discovery acknowledgement. Have you received all the discovery in this case, and did you review it with your client?
I have, Your Honor.
Court will find that the state is in compliance with discovery. Ms. Garcia, I'm showing you what's entitled Application for Deferred Adjudication or Community Supervision. Did you review that with your attorney? Did you understand it, and did you sign it?
Yes, ma'am.
Next, I'm showing you True Bill of Indictment. Did you review that with your attorney? Did you understand it?
Yes.
Court will find, I'm sorry, counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
Judge, I believe there's 2 counts. We're solely proceeding on count 1 and waiving count 2.
Any objection?
No objection.
All right, Ms. Garcia, I'm showing you what's entitled Court Admonishments. Did you review that document with your attorney? Did you understand it?
Yes, ma'am.
And did you sign it in all the appropriate places?
Yes.
You understand what you're charged with is an attempt to take a weapon from a peace officer. That is a state jail felony. The range of punishment is anywhere from 180 days up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes, ma'am.
If you have a plea bargain agreement with the state, the court does not have to follow your plea bargain agreement. If for any reason the court does not follow your plea bargain agreement and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state will call them and right to remain silent?
Yes.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am.
And did you intend to give up those rights and enter into a plea bargain agreement in this case?
Yes.
Did you understand that the court would grant your application for deferred adjudication if for any reason your deferred adjudication were revoked? Court could find you guilty, not grant you community supervision, and sentence you up to 2 years in the state jail facility and up to a $10,000 fine. Did you understand?
Yes.
Counsel, has your client been able to provide you with any defenses to this offense?
She has, Your Honor.
Do you believe she has a rational as well as a factual understanding of the charges against her?
Yes, Your Honor.
Do you believe she's currently competent and was legally sane at the time of the offense?
Yes, Your Honor.
Ms. Garcia, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea bargain agreement to get you to enter this plea?
No, ma'am.
Are you satisfied with the way you've been represented?
Yes, ma'am.
Are you a U.S. citizen?
Yes.
Court will find that defendant has knowingly and voluntarily waived her right to jury trial. I'm showing you the plea bargain page. Did you review that page with your attorney? Did you understand it?
Yes.
According to the plea bargain agreement, there's a $1,500 fine probated. State recommends deferred adjudication. This right concurrent with County Court Cause number 668870. State will take in consideration 672232.
Your Honor,
Yes.
If I may, we, earlier this afternoon, we did the plea in the county court, and that was a JSAT, so we don't need to run anything concurrent. And also they dismissed, excuse me, the violation of protective order. So both the misdemeanors have been taken care of.
All right. Did you understand that to be the plea bargain agreement, Ms. Garcia?
Yes, ma'am.
Defense, is that the plea bargain agreement?
Yes, Your Honor.
State, is that the plea bargain agreement?
It is, Judge.
Next, I'm showing you the paragraph entitled waiver of appeal paragraph. Did you review that paragraph with your attorney? Did you understand it? And did you
Yes.
sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, have there been any such motions?
No, Your Honor.
Next, I'm showing you outside the plea bargain agreement. The state is requesting that your deferred adjudication be for a term of 3 years. There'll be 150 hours community service restitution, no contact with Roseanne Garcia Hissick, Hissick, and Grandma Nick. Yes.
I'm sorry, Your Honor. That was a no harmful or injurious contact.
Okay, it says no contact. Is it supposed to be no harmful or injurious contact, state?
Yes.
I vaguely, Judge, I think maybe we were gonna put that below the line, Judge. I don't remember. I think from our perspective, our only concern was she has picked up some cases against her grandmother and her mother in the underlying cases. I think I told Elizabeth she could ask you to make that a no harmful or injurious contact.
All right, so that is outside the plea bargain agreement, Ms. Sutter?
Judge, no, it was a point of contention, and then when we were in court last week, that was agreed upon. That's my recollection of it, that it was no harmful or injurious contact.
So this is what we're gonna do then? We can recall this for Monday?
Sorry to interrupt again, Judge. I have a vacation letter on file for the last 2.5 months, starting tomorrow, going through next Thursday, or going to next Thursday. I could do it next Thursday.
All right, you're saying next Thursday?
Yeah.
Judge, and I can tell you, Judge, if what you're asking is, does the grandparent and the mother want to have contact with her? Yes, they do. They have moved past, I guess, whatever issues were there. I think the reason we had originally asked for that, if I remember correctly, was just that perhaps because of the cycle of violence stuff, they may not know what's best for them. But obviously, we'll defer to the court regarding that issue.
What we'll do then is we will take the plea, and then we will set it for sentencing. And if the grandmother and the other person want to appear, then they can appear, and what will be will be. I mean, because Ms. Settle, the state is telling me that they're not agreeing. There's only 1 or 2 choices here.
Understood, Judge. I had the complete opposite impression from our last court appearance. That was our only point of contention to taking this plea, and that got resolved.
All right, so what do you all want to do? You can go forward with the plea, and it will be set for a sentencing. And then the grandmother and whomever else complaining can come in and say they want to have contact. Or
Judge, I can tell you that the grandmother has come to we did a motion to amend bond conditions on the misdemeanor, and she fervently wanted that lifted, that no contact order lifted.
All right, so what do you want to do? Y'all want to come back on Thursday and do this plea? Or do you want to do the plea and come back for another date for sentencing?
Judge, to be honest, Judge, I believe they are going to come forward and say that they want contact. So if that's what's going to be the impetus of the court's decision on that, Judge, then I'm okay with it being granted as a no harmful or injurious. They have reached out to our office telling us that they don't fear Miss Garcia.
All right, so what we're going to do is we can come back on Thursday, or either we can do a plea and have the grandparents here, the grandmother and the mom, or whoever the complainants are. Tell you what, I'll make the call. We're going to come back on Thursday, and on Thursday, you all can have the grandmother and whoever the other complainant is here, and we'll take that matter up then. And Ms. Settle, if your client wishes to withdraw this plea in between them coming, then of course, she's more than welcome to do that.
She won't be doing that, Judge. We know what they're going to tell the court, so.
Okay, all right, so we'll be back on, Ms. Ferguson, can we put this on Thursday, please?
Next Thursday, correct, Judge? Or this Thursday? I mean, next Thursday, correct?
Yes, Thursday, the
It's been a
26th.
long day.
Yes.
The 26th, yes, ma'am.
All right, so we'll come back on the 26th.
You know, Judge, will that be in the afternoon again?
No, Ms. Ferguson, even though I know there'll be closing arguments, if you all can be here at 9 a.m., we will take it up at 9 a.m. But if you're not going to be here at 9, no, I'm sorry, I'm not even going to do that. We're going to be back at 1:30. That'll be 1:30. All right, everyone, it's 6:05 p.m. I think we've given, Brenda, we've given our time.
Yes.
And I appreciate everyone giving your time. So Ms. Settle, we'll see you back on Thursday. Ms. Garcia, we'll see you back on Thursday. Ms. Settle, if possible, if you can make sure the complainants in this case are present on Zoom or either in person in the courtroom at 1:30.